This is the House Judiciary Non-Civil Committee meeting. We're here to consider a few bills on our agenda. Let me just, in case folks did not get the notice, it was earlier today. We have removed House Bill 184 and House Bill 336 from this afternoon's agenda. For those who are interested on House Bill 184, please know that we're going to be using the Senate bill, Senator Carter's bill, which is House Bill, do you recall the number? Senator Carter has a bill pending in this committee on the same subject matter. We'll be using his bill as the vehicle, and so we'll just, when we get to Senate bills, which will be either later on this week or early next week, we'll use that bill as the vehicle for our consideration of that subject matter, just to make sure that's clear for interested parties. For House Bill 336, we're going to hold on that for now, work on it. The author is going to work on it in the interim. And just for members of the committee, while it's on my mind, if you've never been through a special session on redistricting, I think hurry up and wait is probably a really good description of it. There's a lot of free time, and we're going to use that free time, free in heavy bold quotes, for consideration of pending matters that come up during this session that we'll need to hold for whatever reason. 336 is a good example of that. The author will go ahead and do some more work on it and then present us with a sub at that time for the special session in what I believe to be somewhere around mid-August. But that's 10th hand reliable information on the schedule. Representative McKillop has House Bill 342 for a presentation today. Representative McKillop, welcome, and the floor is yours.
Thank you, Mr. Chairman. Is that on? There's no light.
It is.
We're good? Okay. Thank you, Mr. Chairman, and thank you for agreeing to hear the bill today. I know we're getting late. I bring before you LC 294768S. It's a substitute. We had this drawn this morning, and everyone should have it in their folder. This is the idea that came out of some folks in Athens, Clark County particularly, and it has to do with the definition of family violence order. That is currently in law, family violence, and I do say that I do look forward. This is my first time in 5 years being before the Judiciary Non-Civil Committee, so I'm very happy to be here. What we've got is the family violence order definition, and currently it deals with temporary restraining orders, protective orders, and other types of orders out of superior courts. What this bill does is go back and add in some things that really logically make very much sense that should be included in the definition of family violence order. And it adds two classes of things. The only real substantive change is on at line 16 and line 18, B and C. And so it adds a pretrial release order, that is bonds with conditions prior to trial, to family violence order. And it adds, after you've been convicted or pled guilty, probation. And what that does is it allows officers, which currently they do not have the ability, but it allows officers who are aware of the violation of a family violence order to go ahead and arrest on site at the time of observing the violation, as opposed to right now with those two classes of orders, that is pretrial release orders and probation orders. They have to go and take out a warrant to have that person arrested, and by that time often these situations can have escalated. Also, the two classes of orders that we're dealing with here, the order for pretrial release and the probation, are violations of those classes of orders can be the subject for felony aggravated stalking. So it does make sense that these are serious issues and serious violations of judges' orders, and we believe that it should be the case that police officers and law enforcement, if they are aware that there is one of these orders in place and that someone is violating one of those orders, they can arrest on witnessing that violation. Right now I'm authorized to state that here the groups that are supporting this change, this addition to the definition of the Sheriff's Association, the Georgia Chiefs of Police, the Georgia Solicitors, the Council of State Court Judges, and the Council of Magistrate Court Judges. They have all taken a look at this bill and agree that this is a logical change and makes sense to add these other classes of orders to the definition of family violence order. I'm happy to stand for any questions. I do want to point out we also have Magistrate Court Judge Auslander here from Athens, as well as our Solicitor General, C.R. Chisholm, I believe Ken Malden, our District Attorney, and also the Deputy Police Chief Alan Brown, all here in case we need any sort of other opinion on this or answer any specific questions about how this would be implemented.
Mr. McKellar, let me ask you, walk us through give us a hypothetical.
Yes.
Walk us through the real-life example of what ill this would address.
Okay, so for instance, for B, that is any order of pretrial release issued as a result of an arrest for family violence. So let's say that there's been an allegation of battery in a family violence context between a husband and wife living together, and there's an issue of family violence for which one party or the other has been arrested. Let's make it the wife. So she has been arrested. Let's make it the husband. Okay. And not making light of it, picking one or the other. So the husband has been arrested for some type of battery or domestic violence. He then goes to bond out, and at the bond hearing, there's both sides, the state and the defense, are making points, and the judge says, okay, I will allow you to bond out as long as you agree to abide by these terms, one of which may be including not going to the marital residence, avoiding contact with the other spouse by 100 yards, if you do have contact, having it be of a completely peaceable and nonviolent nature. Particularly around children. Many of the situations like this develop, and the judges want to go through and put very specific and detailed requirements on people staying together and staying peaceable, particularly when children are involved. And so then what you would imagine is 2 months later, before that individual has come up for trial, the 911 call is placed and an officer comes to the scene. The husband is drunk and violent and, making a fool of himself, and they're in violation of the order. The officer is aware of it. Now, in Athens, we have a docket at dispatch where you can call in and say, is this order still in effect? Who is subject to it? And dispatch says, yes, we have the order. It's on file. He is violating a domestic violence order. And then the officer would then, if we have this change, be empowered to arrest that individual at that time. The way it is right now, the officer would have to basically take the information and go. Even though he knows he's violating an order, he would have to either call or go see, for instance, Judge Auslander, and say, this guy was there at the house, drunk and violent, in violation of the terms of your order. I'd like you to give me an arrest warrant. And then he would have to go back and find that guy as opposed to arresting him at the time. So that's how it would work. It would work exactly the same way after conviction, so that if you've gone in and pled guilty to the battery, and then 3 months later or even a year later, you're drunk and violent again, that he can arrest you without having to go back to a magistrate court and get a warrant issued. It really just saves that step if you know and can confirm that there is an order in place.
Mr. Sessler. I'm sorry, Mr. Coomer.
Thank you, Chairman. A couple concerns and questions that hopefully you can help me address. They relate to subparagraph A to capital A. And two concerns, really. One is that the language says that a family violence order means any temporary restraining order. And the first concern there is that it's broader than just a family violence situation. That's concern number one. And concern number two is that, or I guess the question is, how would an ex parte order be treated under this provision? Would this make a violation of an ex parte emergency ex parte temporary order also a crime?
Okay, I'll take those one at a time. The answer to the first part is, I think, and I can pull the book, but Article 1, Chapter 13 of Title 19, I'm not sure if that relates only to family violence, domestic relations, so it might not apply to any other kind of restraining order or injunctive relief, and I can check that. But then number two, yes, it would, but the language that you're referring to already exists in the code. That's not a change to the law. If you look down at lines 22, 3, and 4, Leg Counsel simply reorganized this section and moved all that up. So actually, I am not adding, or we're not seeking to add anything on lines 13, 14, and 15, as that already exists in the code. So that's not really a change that we're bringing forward.
Okay. If you look specifically at the end of line 21 and going into 22 and 23, you'll see that the words family violence are not stricken through, and those words family violence would have qualified the rest of that language. Would you be amenable to an amendment at line 13 that would add the words family violence after the word any? So that it would say any family violence, temporary restraining order, etc.
No, I don't have any objection to it. Okay. But and like Council's pointing out, it may be redundant because Article 1, Chapter 13, Title 19 only deals with family violence. And so it's already limited in that way. But I would not object to the amendment.
Well, and I don't want to get too far down in the weeds on this, but that subparagraph could be read in such a way that only the last type of order described is subject to the restriction, Article 1, Chapter 13 of Title 19, because you have several different types of orders you relate to, and then the last one is comma or permanent protective order issued pursuant to Article 1, Chapter 13. So, just trying to clarify that all of these have to be limited to family violence orders. And
I would defer to Lake Council, but it's my understanding of how those are supposed to be interpreted in this, and this comes up pretty often, is the modifying clause there at the end applies to everything that is separated by the commas. Is that how we do it? It does.
Okay. I'm sorry. Okay. Thank you, Mr. Chairman.
Mr. Ramsey.
I'll wait, Mr. Chairman.
Okay. Ms. Neal.
I just had a general question just in reference to so does it vary from county to county? Because like in my county we do a warrantless arrest affidavit. So if I saw somebody violating any type of restraining order and I call in, like you said, to dispatch, I can arrest right then. I don't have to do a warrant.
I don't know how that goes county to county. I know I believe in Athens they have to come and swear out a warrant, or in some way.
I can hear you say it again.
And we could have them come up.
The issue would be revoking a bond versus this would be a criminal offense. To revoke a bond, you have to go back to the.
Why don't you come up?
Okay,
why don't you come up here and identify yourself so we can know who you are? And
Apologize.
that's all right. That's all right.
Charles Austin, our magistrate now.
And if you could restate the question, Ms. Neal, and then we'll have a complete answer.
Well, yeah, I just wanted to as far as a matter of info, as far as the difference between doing an arrest on the warrantless arrest affidavit when you see the violation occurring. But I think your statement, if I heard it correctly, probably clarified what I was looking for.
Yes, under the current law, unless there's a new criminal offense that's seen by the officer,
Mm-hmm.
a violation of bond in and of itself would not be arrestable.
Okay.
Or a violation of probation would not be arrestable. That officer would have to go back to the judge who either issued the probation order or the bond and seek a revocation of the probation or bond. And so that's what this would cover, that gap.
Okay. Okay. Thank you so much.
Ms. Benfield.
Thank you. I'm having difficulty understanding why this bill is needed. In the scenario you presented where the husband is on the front lawn drunk and acting disorderly, why couldn't the police officer just arrest the person for public drunkenness or disorderly conduct, criminal damage to property, criminal trespass? I can think of lots of other charges that would be appropriate without having, to me, it just seems illogical. I think under current law, the officer can already make the arrest. It doesn't need to go through the whole warrant procedure.
And under the scenario, the sort of detail-heavy scenario I gave, I agree with you. But it literally could be that the husband or boyfriend, whatever it is, literally pulls up in the street and gets out of his car hoping to go in and talk to her and has not committed any crime at that point other than the violation of the bond restrictions or the pretrial release order restrictions. And the point is to allow an officer to arrest just on the violation. That is, it's a court order. It should be enforced. It can be enforced by arrest. So you don't have to add the drunkenness or disorderly or anything else. He can arrest just for violating any simple condition of bond.
Okay, so you'd agree the scenario that you initially presented does not justify the need for this bill. It's more the situation where some guy is simply going onto the property. And so the scenario that you're trying to address is somebody just simply visiting their property and being able to arrest them.
Or the property of another, or going to someone's workplace.
Okay.
Any other questions for the author? Mr. Setzler.
Hey, Mr. Chairman. Again, I might be slower than some of the other kids, so I might take a third explanation. But what I'm understanding you saying is any per se violation of an order is arrestable under this bill, whereas today it's not.
Of these two additional kinds of orders, yes. Oh, and it's very important, limited to the four things at 25 through 2031. It's only those things that apply under these circumstances. Those are the types of violation of these kinds of orders that need to occur. So they're spelled out here. That is, if it excludes evicts someone from a residence or household, so that if I am subject to an order not to go to a certain address, that is, Judge Auslander said, Doug, you cannot go to that address, and then I do anyway, in direct violation of his order, literally 2 hours later, I just go down there. Then when an officer shows up down there because someone calls 911, I can be arrested for violating the order only. That's all I have to do is violate his order. And that is the reason to arrest.
I might have completely misunderstood you. You said something about it does not apply. You're saying the offense that the person commits has got to be in the list, or it is not included in this list.
This is already the law. It has to be 1 through 4. That is the definition of family violence order, which it says in order to be guilty of violating a family violence order, you have to do that, and it has to include one of these things in this list of 4. Exclude someone from a residence, keep someone from around a person, things like that.
What are some things that a judge might order that it would not include? Help us kind of
let the judge answer.
Give us 3 or 4 examples on the would not include side and 3 or 4 examples on the would include side, just so we can kind of get an intuitive feel.
I mean, I think the main thing...
Judge, if you could talk, move a little closer to the microphone.
Yes, Mr. Chairman.
Thank you.
Representative, I think the main issue that we run into, and I do have the Deputy Chief of Police and our solicitor here that might be able to address it better, but when there's an order that tells someone do not go back or do not have contact with this person, and there's a violation of that, the process now is that the law enforcement have to come back and they have to file an affidavit. There's a hearing set, and then we have a hearing to determine whether or not to revoke the person's bond. During that time frame, there could be a 2 or 3 week delay when there could be a serious violation going on. Now, the officer in the street would have discretion to make a decision whether or not it's something that they might wish to arrest for or bring before a judge. But if there was a serious situation such as do not come here and the person is there and the victim is calling, it would allow them that discretion. Something along the lines of there's a lot of conditions of bond that this would not cover, such as requiring a person to go to AA or requiring a person to get a job or whatever might be a condition of bond. This is specifically targeted for violations of serious contact that might be place a victim at risk.
I'm sorry. I'm done, Mr. Chairman.
Ms. Benfield, want to take another crack at it?
I just have concerns. I certainly hear what you're saying, Judge, and I appreciate you coming to testify. When I was actively practicing family law, I represented men and women. I know in these family violence cases, typically what's done is there's an automatic restraining order issued right away on both parties. And I've had cases, and I can think of the worst case scenario, but I can, as far as there being a violent situation, and frankly, I think in those cases, the police is already empowered to make an arrest. If they see any type of violent conduct, there are ample laws on the books already to address those situations where they can make that arrest. But my concern is the case where, and I've had this in some of the cases I represented, where it's usually the husband who's going on the property to retrieve some of his belongings. And the police get called, and under this, I could see where he gets arrested, and then he's got an arrest record. And we're going to deal with expungement later, and so hopefully that will ease some of those concerns. But I'm very concerned about somebody having an arrest record now for coming on the property that's their property as well to retrieve their personal belongings.
Do you want to respond to that?
Just briefly, I think that's already the law. You're talking about in a domestic relations situation where there's already a restraining order. And so I think that's already the law at lines 20 through 24. What the example that you gave, if somebody's in a divorce and there's a restraining order and someone goes to a house, then that's already the case. All this does is expand the definition of the types of orders to an order that is pretrial release after someone's already been arrested. So they've already been arrested. It's not a brand new arrest record. This is they've already been arrested under the changes that are here. So let's be clear. Or they've been convicted or pled guilty. And so it doesn't really apply, because in these situations you have to have already been arrested for what we're trying to change here to take effect. So I can definitely understand your concerns about creating an arrest record, but under the changes that are here, somebody has already been arrested before this would kick in.
Okay. If I may follow up, I see the point. You still have them being arrested for potentially doing something that's fairly innocuous. Back when I worked in magistrate court, I routinely saw on Monday mornings where usually the wives would get upset with the husbands and just make sure they got arrested on Friday, knowing good and well that they'd have to spend the whole weekend in jail. So I'm a little concerned about how fairly innocuous conduct could lead to a second arrest.
And I understand your concern, Representative Benfield. I guess the saying that it's innocuous might be in the eyes of the person evaluating it, but maybe in the eyes of the victim, a person coming back without permission or without police presence, if they've been told not to come there, might not be as innocuous. In our situation, anytime we send somebody back to get belongings, we always make sure they have a sheriff's escort or a police escort. And I think the magistrates, Superior Court judges, state court judges issuing these orders are very clear to look the person in the eye and say, you cannot go back to that house. And so the issue is, if they've heard that from a judge in person, been delivered a copy of it, if they violate that, then they've done so knowingly. And so it may not be as innocuous as it sounds.
Yeah, I'm just trying to, and I appreciate you with that concern. I'm thinking of the worst case scenario on the other side, and not every judge. I think most judges are diligent like yourself, but I just want to make sure that persons don't get caught up in this.
And I hope that the law officer on the street, they all have the discretion not to arrest if they don't believe, so they can take it back to the judge. We'll be able to also evaluate that.
Mr. Ramsey.
Thank you, Mr. Chairman. So, and you address in your answer my first question. You were already talking about people that have been arrested for a family violence offense already. But you strip it all away. All we're doing here is giving a law enforcement officer the ability to enforce an order that's in place likely to protect the safety of the party that is being subjected to its protection that was already a victim of family violence, correct?
Exactly.
Okay. Mr. Chairman, at the appropriate time, I'd like to be recognized for a motion.
All right. Mr. Vice Chair.
I just want to say, am I on?
Yeah, you should be. Yeah.
All right. I just want to say, I think that it's, the bill is, I'm sorry. Testing.
There we go.
I'd just like to say, I think the bill is needed because basically, from my standpoint, there's a lot of times you have those orders that are out there and you have a violation, but you've got to wait until a hearing can be convened in order to actually do anything to give any relief. And so this is going to be giving litigants opportunity to be able to get some help from local law enforcement, which I think is not an unreasonable thing after a court order has already been entered. And I would just hope that you don't think we'll have any issues about the interpretation of orders by law enforcement, do you?
No, I don't think so. I think we have very narrowly, actually this is a substitute because we took out good behavior bond because literally we didn't want to open up that kind of what is that, who's got one. We narrowed it down to only after you've been arrested, only after a judge has looked at you and said, don't go near there.
Right.
And then you do it. And so that's exactly, and thank you for the question, that's exactly why we narrowed it down and why you have what you have before you today.
Chief Brown or Solicitor Chisholm, would you like to come forward and be heard, or has it been said? You're welcome to give us your comments if you'd like, since you're signed up. All right. All right. Very well. Shelley Centerfit with the Georgia Coalition against Domestic Violence. Ms. Centerfit, did you want to add anything? All right. All right. Very well. What's the pleasure of the committee, Mr. Ramsey?
I move do pass the substitute to HB 342, which is LC 294768S.
Mr. Ramsey moves do pass of HB 342 by substitute LC 294768 S, second by the Vice Chair. Is there any further discussion? Any amendments? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. McKillop. Our judge of the week this week is Superior Court Judge Mike Boggs from Waycross. Judge Boggs, welcome, as always. Judge Boggs, for those who don't know, is a former member of the House. Had the troubling experience of sitting next to me for 4 years, which basically drove him out of the House and made him run for judge up in Waycross, and he did so by a huge margin, which is no surprise to anybody who knows him. We appreciate your being here, and like I've said to all the judges, always you're a resource. If you see something, you see us going down a path that may not translate into the real world of the courtroom, in your opinion, from your experience, both here and there, please let us know. We look for that resource, and we look for that help. So thank you for making the trip, especially from that distance. All right. I think Mr. Welch is in the holding room. In the holding cell. Good Lord. Representative Welch, welcome. We're here to consider House Bill 421. Members should have a substitute in their folders, LC 294741ERS. There's also a handout being handed out by Ms. Bazemore right now, Process for Individuals Incompetent to Stand Trial. Mr. Welch, this is something that is being handed out from you. Is that correct? Yes. Okay. Sort of a flow chart of the competency process, I suppose. Yes, sir. Does everybody have that? All right, Mr. Welch, welcome.
Thank you, Mr. Chairman. Thank you, members of the committee. It's a pleasure to be here this day. It's 11th hour. If you will, what I've done is I've given you and this is provided by the Department of Behavioral Health, and you'll see here this is the process for individuals incompetent to stand trial. This may be helpful to you as I explain the bill, just to follow along to understand the process. And what the bill currently does, House Bill 421, there's an LC, it's LC number 294741 ERS. That's what you should have in front of you. This was passed out of subcommittee with unanimous support. And what this bill does is it revises the current law on how we determine competency to stand trial in the criminal context. And the first thing it does under Section 177-129, beginnings on line 20, thank you, is that it now specifies, and the current law does not do this, but now it makes clear that a defendant or an accused, criminal defendant, and the terminology in here is an accused, may submit for a motion to have an evaluation done. The first section, the first section there allows the court, if the court believes that there's sufficient evidence that raises the question of competency and that the accused is not able to communicate with his defense counsel, or if the accused is pro se, unable to understand the process. In that case, this tracks current Georgia Supreme Court case law that authorizes the judge sua sponte to call this into question and to raise the issue and then to have an evaluation. That's currently not codified, but under this bill it would be codified, so we are codifying case law in that respect. Section B on page 2, beginning on lines 32, also calls for the special plea. And remember, this where it's currently codified in the code book is that this is the defendant's special plea to raise the issue of competency. So that is preserved, and Section B says that this talks about the evaluation in the case of a special plea. So if the defendant raises a special plea, the evaluation will be done, and it will show how the evaluation is to be dispersed. Looking down at lines, we've amended the definition sections. One amendment that I want to draw your attention to is line 43. Civil commitment means the accused is involuntary. The accused involuntary inpatient or outpatient commitment, pursuant to the two code sections or two chapters that call for involuntary commitment, chapters 3 and 4 of Title 37. And I just point that out to you so that when we talk about civil commitment, it could be either inpatient or outpatient. We also have changed the terminology with respect to violent and nonviolent offenses. We have added the definition of violent offenses and spelled those out on page 3. And we have added also the serious violent felony and sexual offense. Those are two violent offenses that are specifically defined. As you move through the bill on pages 4, 5, 6, getting to 7, you'll see this is the old language that's been struck through and revised. In code section, there will be on line 227, subpart B1. This codifies what is kind of current practice where the defendant asks for an evaluation. Not saying that he or she is incompetent, but wanting to, the defense counsel typically is, or a guardian ad litem is appointed, is saying, I need to check with my client. I want him evaluated or her evaluated to see if he or she is incompetent to stand trial. So now there's a codified motion, which has been in current practice but just not codified, that calls for an evaluation of the defendant. And then that evaluation remains held and sealed. It goes to the defense counsel. It would go to the court, but otherwise remains sealed unless the defendant raises the special plea of incompetent to stand trial. Then it will be passed along to the prosecutors. And that's taken care of B1 and B2. Now, what happens in the case of the court finding that the accused is mentally incompetent to stand trial? What happens next, and this follows your flow chart, is after a hearing on the issue of competency, which must be held under this bill within 45 days after the evaluation is performed and the report is given to the court. That 45-day period is important to the Department of Behavioral Health because it provides a definite stop period, a definite hearing date. And what has happened is that sometimes they'll do an evaluation and the defendant stays with the department or stays incarcerated for an indefinite period of time while waiting for a hearing. That winds up costing taxpayers money, and they may be held in the department for a prolonged period of time unnecessarily. So the judges that I've worked with on this bill would like to see that change. Testimony was given during subcommittee in that respect. The 45 days was agreed upon between the department and judges, so that seems to be a good way to handle it. Now, what we also had to include in this through subcommittee was that the way the current law reads is that it's a special jury trial to determine competency. In other words, a jury would have to be called, summoned, and paneled, and then vaudeered, and then testimony given at that hearing. This could be a 1-day to 2-day proceeding depending on the complexities. It was requested that this be changed to a bench trial. In subcommittee hearings, we heard strong support for preserving the right to have a jury trial. What this supplement does is that it makes it automatic bench trial, but the defendant can move for a special jury trial. So the option is still there for the defense to request a special jury trial. Otherwise, the default will be a bench trial, and in that case, a special jury would be impaneled if requested. If it's demanded, a special jury trial is demanded by the defendant, then that trial would have to be held within 6 months of receiving the department's evaluation. So that's the time frame that's been put into law. If we move this through, will be a 6-month period to have that hearing on competency for the special jury, 45 days if it's a bench trial. If after the accused has been found to be incompetent to stand trial, the process moves to the department, where the department has to determine whether or not the person can be rehabilitated to the point of being competent to stand trial. And that's under subsection C, lines 242. And in this case, what happens is the department takes on the accused, does further evaluations to determine whether or not the accused can be made competent for trial, and if he or she can be made competent, then they are remitted back for the trial. If they're cannot be made competent, then they'll be held for another period of time, which we get into in the statute. But subsection C goes through what happens in that through that process. Lines 250 talks to if the accused is determined by evaluation to stand trial, the department reports that, and the accused is returned to the court pursuant to subsection D, and we'll get to that in a minute. If the accused is mentally incompetent to stand trial and there is not a substantial probability that the accused will attain competency, then we go to subsection E, which we'll get to in just a second. And if the accused there's a high probability that the accused will become competent, then we go through an evaluation process and further treatment to try and bring the accused up to the level of competency. That is a limited period of time of maximum of 9 months. The Part D deals with the situation where the individual is determined to be competent, and who's going to hold the person, the sheriff or the department, while after the evaluation has been done, but while we're waiting the hearing. So that's that 45-day period or the 6-month period. And in that case, the sheriff would normally hold the individual until the hearing. Otherwise, the department may hold the defendant in case it's necessary to maintain a level of sanity, or it's not insanity, but a level of competency that would allow for the defendant to go through the hearing and move forward with trial. Again, 45 days, they'll have a hearing. 6 months if it's a jury trial. That's covered on page 9, lines 295 through 300. In subsection E, this is the situation where the defendant accused does not have a substantial probability of becoming competent. So what do we do with the person? And in that process, if the accused is charged with a misdemeanor, then the accused can be detained, and there will be a hearing within 45 days to determine competency. If it is determined that they're not going to be competent, then the judge has 2 options. They can dismiss the charges without prejudice and remit the person to probate court for what's called a civil commitment. It's an involuntary civil commitment. Or the accused could be bonded out. If the accused is charged with a felony, on page 9, beginning on line 319, if the accused is charged with a felony, then the evaluations will show either one that is competent to stand trial, and it goes through the process for, let me make sure I'm on the right. I'm sorry. Subsection E, beginning on page 9, go to line 319, that's correct. If charged with a felony, then there's a determination as to who's going to hold the individual. They can be held by the sheriff, or they can be held by the department. There'll be a hearing held to determine whether or not the charges should be dismissed, and the individual sent to probate court for a civil commitment, involuntary civil commitment. The other option is that they would be bonded out. If the individual is charged with a crime and he's going to be held for civil commitment by the court that has jurisdiction, and he's charged with a nonviolent offense, felony, then the duration of holding that individual in a civil commitment process, an involuntary civil commitment, would be either the maximum length of the sentence for which the individual was charged or 5 years, whichever is greater. If it is a felony of a violent offense, then the individual will be held in civil commitment for a period of the longest sentence for which the individual was accused and could have been sentenced. And that would be the maximum duration. Now, under either scenario, there is an annual review of the accused done by the department, and the accused has the right to petition for a rehearing of his or her competency, as well as the prosecution has the ability to at any time call for a rehearing on the individual's competency. So there's an annual review that must be done, and there's a mechanism by which the accused can seek relief annually. Now, what's important about this is that there was a case by the U.S. Supreme Court, Jacksonville, Illinois, in 1972. That case spoke to the issue of how long may departments hold individuals. And it's in those procedural processes of how long may you hold someone that's not, we haven't tried them, we haven't determined their guilt or innocence, but yet they're not competent to stand trial, how long do we hold them? And so this bill puts those boundaries on how long we're holding individuals. It sets the outside boundaries as opposed to being indefinite. Moving down to 378, subsection F on page 11. At this time, this would allow for, obviously, for the department's physician to notify the court at any time they believe that the person has become mentally competent to stand trial, and the accused, of course, can, if so, then the accused will go through the subsection D, which will go for another hearing for determination of competency and move forward from there. Subsection G allows the accused, allows the state to file a motion at any time for rehearing on the accused mental competency to stand trial. Those are the major provisions. I'm sorry to walk you through all of these like that. I know that it's strenuous, but I'd rather have gone by it as thoroughly as I could. And I would like to just mention to the committee that this has been a labor of love. It's been a bill that we've worked on for well over a month or so on this particular bill, and I believe that today from the department we have Ms. Karen Bailey Smith, Ms. Betty Bentley Watson, and Ms. Lavin Gartland here from the department to address further questions that you may have. But I've worked with them. I worked with Judge Kathy Goslin and Sam Goss and also David Emerson on this bill. These judges have been active in behavioral health and on this issue of competency, and they came and testified before the subcommittee. So I'm happy to have them here. They've been active in participating and giving me feedback on the bill. And then you also have an amendment that's there before you. This is an amendment that's been requested by the department. You'll see that goes in by replacing line 245 with the following language. And this has been requested by the department, and that's for your consideration. And I'd be happy to take any questions that you may have.
Thank you, Mr. Welch. This bill went in late, but I've seen you working on this. I think we all have, and I know you've really been put forth a very concerted effort, and we appreciate your focus on it. Let me go ahead and get a report, if I could, from the subcommittee. Mr. Ramsey, anything you want to add from your subcommittee's consideration of the bill before we get to Q&A?
Very, very little, Mr. Chairman. I want to echo your comments. Representative Welch has really, really put a Herculean effort in over the last week to 10 days getting this bill, certainly leading up to subcommittee, and then overnight from one subcommittee hearing to the next to get it in a form that's that was able to garner the support of the subcommittee. It was interesting. We heard two judges from two different circuits testify that they didn't know if a defendant could even, based on the way that they read the code, whether a defendant could even waive a jury trial and have a bench trial. So you have two different circuits interpreting the same law differently. In one circuit was even if a defendant and defendant's attorney wanted to waive the jury trial. They weren't allowing them to do it. So this is clearly an issue that needs to be addressed, and it took a little bit of, I think it took a little walking it back just a little bit from where it started, where now there's an option, and I think that made some of the folks in the defense bar community a little more comfortable. But I think we also recognized there was going to need to be a little bit more perfecting between subcommittee and full committee in the interest of time, and I think you see the amendment here. But the subcommittee ultimately approved it unanimous, Mr. Chairman, and we all certainly appreciate Representative Welch's good work on it.
It's a heavy lift. There's just no doubt about it. It's a true heavy lift. Just for clarity's sake, on the default to the bench trial, and you say they make a demand on the jury trial. Is that a jury trial as a matter of right, or is that discretion preserved in the hands of the judge?
No, it would be a matter of right. Once the defendant demands a jury trial, then a special jury will be impaneled.
All right, Mr. Pack. I'm sorry, Mr. Atwood.
Thank you, Representative Welch. I support you in your bill. If I could direct you to line 227, page 7. Line 228. It says if an accused files a motion requesting a competency evaluation, the court may order the department to conduct an evaluation by a physician or a licensed psychologist. Is physician defined? I couldn't find it. Is it defined in here? Because I have some question. That could be read a GP vice a psychiatrist or a specialist in that area. I think that might be problematic.
The current bill actually uses both that language. The current law uses physician or licensed psychiatrist. So we had pared it back to a physician, then we went back, broadened it back out to licensed psychiatrist, a psychologist, so that generally speaking, I think the department can speak to this with more accuracy than I can, but my understanding, generally speaking, that it is a licensed psychologist that's involved in making the determinations. But bear in mind that in either context, the weight of that evaluation will be judged by the jury or the judge in that context. So I think that goes more to the matter of making the best evaluation, who will be the best witness in terms of making that evaluation. So we didn't tinker with that too much in the current law.
Thank you.
Mr. Coomer.
Thank you, Mr. Chairman. Just briefly, have the Council of Superior Court Judges or the Prosecuting Attorneys Council weighed in on either of these? Either of those groups weighed in on this bill?
No, obviously I mentioned 3 judges that have worked closely with this. I have not received any negative comments from the Council of Superior Court Judges, and if there.
Judge Boggs, are you in a position to comment on that?
The council has reviewed the bill. The 3 judges that the representative referred to were working here on behalf of the council, and we've reviewed it and we're satisfied.
Thank you, Judge.
And then as for PAC, I've kept Mr. Chuck Olson. I met with him very early in the process, and he gave me suggestions. One of those suggestions was changing the definitions of violent versus nonviolent offenses, and we've incorporated those changes in. There are other changes that I have chosen not to make, and that was allowing the prosecutors to raise the issue of incompetency and to seek an evaluation. And this was preserved. We did not go that route to preserve their Fifth Amendment rights from self-incrimination. Once it goes to an evaluation, the courts and the attorneys lose control over what is said in that context. And so we cannot be certain as to what would be reported during an evaluation. Even if the evaluation is narrowly tailored just to the issue of competency, we felt that we need to leave this as a special plea reserved to the defendant as it currently is in current law, and not intrude upon potentially Fifth Amendment rights.
And the Prosecuting Attorneys Council, to your knowledge, haven't stated any other specific objection to the bill?
No. I think Mr. Ken Malden is here, and he has some concerns with the bill that I think he will raise with you today.
Thank you.
And I see Stan Gunner with the PAC as well, so they'll have their time to register whatever they want to bring to our attention. Down the line, Mr. Setzler.
Hey, Mr.
the author. We had spoken earlier, and I don't know if you wanted to address it or if you're going to leave it to some of the other witnesses to testify. Section 5, where the department notifies victims currently of the release or discharge of an individual. Did you want to address that at this point, or did you want to wait?
I'm happy to address it. I think the department will speak more to it, but just to share with the full committee our communications between Representative Setzler and myself, Section 5 is problematic to the department, and they will explain more in detail why. And the current law is there before you, and you'll see the language being struck. And if you read it, you'll see that the burden is on the department to notify the victim if the victim has given a request. But if the victim has made a request to be notified as to the department's actions, then under current law it deals with release or discharge. In that case, the department has full control over the accused. But in the case of these hearings that go on as a result of competency, to determine competency, those hearings are going to be conducted by the court. And so the department's concern is having the obligation to provide notice of hearings to which they may or may not be a party to, the date setting of those hearings, and that would entail applying resources to provide notice for hearings that they're not really in control over. So that's their concern, but I'll let them explain that more to you.
And to that question, I don't want to cut to the punchline. I just wanted the committee to understand that you're aware of the issue and that you're comfortable that Section 5 may not be an essential part of this bill in your perspective? Or? It
is not. From my perspective, the goals to be accomplished is to change the nature in which we conduct these incompetency to stand trial issues, bench versus jury, and to try to streamline and bring this law more in compliance with the Supreme Court case I mentioned to you earlier. So I have no objection to Section 5 being modified or eliminated to the extent that it serves the department's purposes. But other than that, I'd like them to explain to you their issues behind it so you can make that determination.
And Mr. Chairman, I'd just like to thank Representative Welch as well. Was very very committed to working with the subcommittee and listening, and I appreciate the work product you've got here. So,
thank you.
Ms. Benfield.
Thank you. Just a couple of issues. I just want to make sure I understand the differences between what you're proposing in the existing law, and correct me if I'm wrong. I see the main changes is this allows the judge to sua sponte ask for a competency evaluation, which is not allowed under current law. This is more technical, but instead of DHR, it's the Department of Behavioral Health and Disabilities that's now doing the competency evaluation. And then there's now a bench trial option. Are those the main? Are there other significant changes? Because I'm pulled out the code and I'm trying to compare what's under existing law, and I'm trying to remember. I've done a few of these cases, and I'm trying to remember the procedure. Are there other main changes?
You have, Ms. Benefield, Representative Benefield, you've nailed it on the head with respect to those particular changes. In addition to that, we have set time frames. The 45-day, 6-month rule for when we have a competency bench trial or special jury trial was essential to the departments moving forward, and with the judges to try and have some sense of when this is over, when we've decided this issue and moving on. So, so the time frames are important. The time frames also with respect to holding someone for where they're involuntarily civilly committed after they've been found to be incompetent, and there's no likelihood of bringing them to a level of competency. Then there was a need to define the outside time frame in which one would remain under the jurisdiction of the court, subject to the jurisdiction of the court, as well as being held, because as it is right now, it's indefinite. So with those changes, we think that this makes the bill stronger constitutionally, and we also think that it addresses some department issues that they had.
Can I ask just a few quick follow-up? And the time frame is so important because I do remember when I handled some of these cases that they would tend to languish in facilities that weren't appropriate for them. On the top of page 2, court. Let's see where there's an evaluation done. Let's see. I'm looking at line 28 and 29. Is there a time frame for when that evaluation is conducted?
Typically, these evaluations, no, ma'am, there's not, and the reason why is because practically these are typically done. The department is here to can speak more to that question. But my understanding is, and I'm sure they'll correct me if I'm wrong, is that that the way these initial evaluations are done is that the department will send someone to go to the jail, to the holding facility, and interview the person to make a preliminary initial evaluation. And so that's generally how that one is done. And then once that evaluation comes back to the court, then what the court can do under this particular new code section 129 is the court can then sua sponte say, I have enough concern here that we need to move forward with with a hearing on it. And so then that would allow the opportunity of a special plea, and it opens the door for a full hearing on the individual's competency. So, no, ma'am, there's not a time frame there.
Okay. My only concern there is I do remember when I handled some of these cases that there was sometimes a lag, and it wasn't necessarily with DHR, but it was whoever was doing the evaluation. Mm-hmm. And we were just waiting and waiting, and as you know, if it's pre-accusation, pre-indictment, you don't have the right to a speedy trial. So that's a concern, but I don't want to put an unreasonable burden on the courts either. And then one final question on page 7, line 227, the very end. Was there thought given to that being a shall as opposed to a may?
227. Yes, and it. I think under current law, I think it's shall, if I'm remembering correctly, and I may be mistaken on this, but at one point there was a draft that had the word shall in there. We went to may because it may be the wishes of both parties, the defense or the prosecution. In the case of the defense may want an independent evaluation, not one done by the department. And we did not want it to mandate the court be restricted to just using the department. If someone wanted to pay for their own, why not go that route? So that's why we went with a may as opposed to a shall.
That makes sense.
Yes,
Last, what I think is a friendly amendment. It's actually proposed by Representative Abrams, but she had to run to a meeting. On the amendment, she has an amendment to your amendment. Okay. The AM 29-1021, just line 4 instead of done, that the word be performed, and that's more consistent with the language used in the code. And that's also the language found on line 5. If she comes back, I think she'll make that motion, but I wanted to go ahead and give you a heads up that that was a minor tweak.
And I don't have a problem with it. The department may speak to that.
Okay. Thank you.
Mr. Welch, thank you for your work and your presentation. You're excused for the moment.
Yes, Mr.
Ms. Lavin Gartland. Ms. Gartland, if you come forward, I see you signed up here to speak. If you could try to keep your comments brief, we'd appreciate it. And if you could just let us know who you are and your capacity and so forth.
Thank you, Mr. Chairman and members of the committee. My name is Lavin Gartland, and I am the Assistant Commissioner of Public Relations at the Department of Behavioral Health and Developmental Disabilities. We appreciate Representative Welch's work on this bill, and thank you so much for his time. We do support this legislation with 2 changes on line 245, as he suggested that's in this amendment, and then also on line 245, the change from such to thee, and then our other request would be to delete section 5. And I have with me 2 experts from the department, Betty Bentley Watson, who is the attorney for the department, and also Dr. Karen Bailey Smith, who is the State Director of Forensic Services, that can speak to specific details if you have any questions.
Are there any questions for the department? Seeing none.
Thank you.
Thank you, Ms. Garland. We appreciate it. Mr. Gunner, did you have any comments? Or all right, Mr. Malden, did you want to make any comments on behalf of the District Attorneys Association? Okay.
Mr. Chairman, members of the committee, I'm Ken Malden. I'm the district attorney for the Western Circuit that covers both Clark and Oconee counties, and serve as the president of the DA's Association of Georgia. And members of our association, including myself, have also worked very hard on this matter for the last couple months, I guess, and worked very closely, I believe, with the folks from the department and sat down, hours on end, as well as folks with the Prosecuting Attorney's Counsel, Joe Burford, for one, and came up with certain drafts. We also worked with Representative Welch and talked to him about a number of different matters, and I personally submitted different drafts to him well before now, as we've been doing this. I've also had presented to him last week when we started kind of the substitutes started flying and they started coming in subcommittee, as it were, and had actually, at his request, had submitted proposed changes, that we would have in that regard. I know he'd indicated he was going to try to consider those and that kind of thing, that I'd submitted those in writing to him like that. I have copies of that. If I could pass that out, perhaps. I know it's at that point, but I could go over some of the matters that we have with the Chairman's permission, one way or another. Whatever your feeling is, or if this is a matter we ought to just deal with later, that's fine too. But
I mean, if there is a significant structural or either a significant structural problem or just a pure policy disagreement,
well, I can go over some of the different matters that I'm talking about, and that may come up and would be up to the committee, and of course we could bring those up later if the bill progresses. But
I think that'd be appropriate.
Okay. Under the first section, we had really looked as far as that particular section, and I brought it to his attention when I first saw that section, after a substitute started coming through, I guess, committee.
But let me and I apologize for interrupting, but let me just caution you. What I would ask you to do is to point to specific language that causes a specific problem and a specific remedy to that. Thank you.
I had pointed out to him, I think, our issue with that particular code section altogether, that new code section, 17.7.129, and basically suggested to him that should be struck. And the reason was not because the judge does not have authority sua sponte to bring that up, but really because of the way that was worded in there, because it seems to imply the judge may very well somewhat start predetermining what the evidence may or may not be, even though you're asking them at some point for a bench trial in that regard. Because it winds up saying the judge can sua sponte bring that up, which we fully support, certainly. But it says in here, like on line 25, if the court determines that it is necessary to have a trial on the issue of confidence, the court shall follow the procedure set forth. And then on line 27, the court's order shall set forth those facts which give rise to his bona fide doubt as to the accused's mental competency to stand trial. If, in fact, the court is basically setting out facts which actually raise some sort of doubt about their competency, and then later on you're saying there is actually a bench trial on that before the same court, I think those are some matters I think we would have some concerns about, as it appears like the court being in a position where the court's already making some decisions about that, and then all of a sudden you're having them decide that. In addition, in discussions with Representative Welch all along, as well as with the department, there was a feeling about about having a bench trial altogether, and about that. And I understood, I think, when it was coming up, that there was going to be a feeling that either party could request a jury trial. And I think the language that we saw there was a situation where only the accused could request a bench trial. And that seems analogous to what the legislature did several years ago, where a defendant particularly could request a bench trial, and the prosecuting attorney had no right to ever have a say-so in that. And the state of the law now is, on a regular criminal case, that the prosecuting attorney has to consent to that bench trial. If we want a jury trial, the case could be tried. And that was one that was seen, I believe, by prosecutors at the time, that in death penalty cases, if in fact the defense attorney felt that there was a a judge that may be not necessarily inclined to provide the death penalty or whatever, that they may say, well, let's go ahead and have a bench trial. And then there was a bench trial over the prosecutor's objection. And this may be a similar type of situation where they felt. So the suggestion I would make, or that we had made in proposals, would be that you would have actually a opportunity for either party can request a jury trial. And it could be in any case, or maybe just in a felony case or any violent case, however it needed to be. So that was a matter that we felt that was important. In addition, and that was in addition, in real life, when you wind up having these matters, if the department came back with an evaluation that feels that the person is not competent, routinely the other side, it would be the state, could be one where we would actually request an independent evaluation. That's one of those ones we would have that right to be able to request an independent evaluation. So what I've done is we've been talking to them, indicating that we would actually make sure that that's clear, that somebody could ask it for an independent evaluation. It wasn't one that all of a sudden everybody has to accept the department's evaluation. And there have been some times we have not actually accepted the department's evaluation. I'm not going to go into examples, but I think in real life you would actually have some sort of independent evaluation, perhaps by either party, like that. So that was another matter that we brought up. And again, these were not matters that were not new. These are matters that we've been basically dealing with over a period of time and talking about and bringing in the drafts that we presented, in extensive drafts about that, as Representative Welch mentioned. There was a concern as well on line 291 where it winds up saying that the court shall hold a bench trial to determine the accused's mental incompetency to stand trial. There was some feeling in that version that we saw once we actually saw that particular substitute, that folks could read that as being burden shifting. Where now, instead of right now, in one of these cases, it's a civil matter, and there's presumption of that the person is competent, and the defense has the burden of proving by a preponderance of the evidence that the person is not competent. That one of those criteria, one of the three criteria, they're not able to understand the proceedings, understand their condition in relation to those, and able to help their lawyer. Any one of those. But the feeling is, if you wind up saying that the person, they have to show that the person's incompetent, there's a trial to determine the incompetence, it may be the state is now required to be able to prove by preponderance that the person is competent. And I believe there was a feeling that there may be burden shifting when that language actually came out, when we saw, that substitute that came out at the end of the week. And really, we were cautioned, I think, all along in working with the department about cases that were pending in the 11th Circuit in regard to anything in regard to burden shifting. So that was the feeling. On lines 313 and 333, when it talks about dismissing a charge without prejudice, we'd suggested language about dismissing the charges with the consent of the prosecuting attorney instead of without prejudice. Because generally courts don't just dismiss charges unless it's something that that the prosecuting attorney requests, like that. And on line 377, we had suggested adding some language to make sure there was a hearing if, in fact, the defendant's release is ever considered, or somehow there was some sort of a lesser supervision of some sort, really to make sure that the Crime Victim Bill of Rights was applicable to those situations, that there was actually a hearing. I had an email today about a case that's pending in our jurisdiction about competence, and where the victim is very concerned about being there and being appropriate as far as whether or not, if the person's ever considered to be released like that. And then lastly, I had not seen the amendment. I think it was talked about in regard to striking that language, particularly striking Section 5. That's the first we learned of that today. We would be opposed to that. In fact, we had suggested language that would actually ensure and add in there that in any judicial proceeding scheduled pursuant to Code Section 17 or 17 or Title 17 of Crime Victim Bill of Rights shall be applicable. so that the Crime Victim Bill of Rights would be applicable to these matters as well, so the victims would be notified and have a right to be present, because they really do care about that. It does matter to them a lot. So we would respectfully accept to that change that's come about on Section 5. We're striking that, and I understand the department's concerned about them notifying folks. But there is a concern about them notifying. But I think there ought to be added protection that the Crime Victim Bill of Rights is applicable to those hearings, because it is a matter, if you get ready to release somebody, the victims ought to be there. That case is still within the breadth of the trial court itself. And so if there's some idea that they're going to now be released, or in fact their supervision is going to be less, and there's some chance of them actually seeing that person on the streets, they ought to at least know about that. So again, these are matters that we have been very diligent about from the start. We have talked with the department throughout the process, and we have communicated with Representative Welts, and he has worked very hard, and I have to commend him for that. He's been willing to listen and everything else to go through that. And but believe me, these are not new matters. These are matters that we had continued to work with him about as we continued to see a sub and to see exactly what that looked like to try to make those changes as best we could. So that's where that was. And I
thank you, Mr. Malden. I appreciate your comments and your candor. Let me ask Representative Welch, did you want to address directly any of Mr. Malden's comments on, if you would, why don't you just slide over to the, use the second mic. No, that's all right. We've got the second mic there. Yeah.
If going backwards in time, if we will.
Sure.
The last point being Section 5. If the committee members will just think with me just for a moment about the situation, in addition to what I just had told you about Section 5 with respect to the department's concerns, we are talking about a person that's not competent to stand trial in the custody of the department after it's been determined that the person is not competent and being held, and then we have subsequent rehearings on this matter. That is outside of once determined not to be competent and once determined and once civilly committed. That becomes a civil issue. I mean, we're talking about a civil hearing from then on out. So I just want to give that to you as a perspective, that we're no longer in the criminal context, we're in a civil context. And the way this is, the language that's been added in here, while I understand the point of it, and I don't disagree with Mr. Malden's wanting to keep the victims aware, we're in a civil context, not in the context of the criminal, in the criminal context. And furthermore, we're shifting the burden to a department to tell the victim when these hearings are going to be held, when the department is not in control of the hearings. So the concern, I don't have any problem with notice. I don't have any problem with notice. The question is, who needs to provide the notice? Does the department need to be providing the notice, or does the prosecutor need to be providing the notice? So that's, or the court. And so I leave that to you. And then moving backwards, I don't have a problem with the change that Mr. Malden has recommended with respect to line 291, because I understand his concern where we would strike the IN in competency. Jill, do you have? I don't have a problem with that. I think that is a concern that needs to be addressed, so that sentence would not have the word incompetency in it, but rather have the word competency in it. As for the suggestion at line 313, dismiss charges without prejudice, I think this tracks, if I recall correctly, current language, and what we did, we added, I think, the without prejudice in there in order to move the case over to probate court. And so you're no longer having control over the defendant in terms of a criminal situation, but moving it to probate court for that determination of civil commitment. Certainly, I think the reality of this is that I don't expect a judge to summarily dismiss anything without having both parties present. So I think that will be the case, and I don't think the language needs to be changed. I think it's sufficient the way it is. As for initial comment made with respect to section 129 that begins on page 1 at the bottom and rolls over to page 2. Mr. Malden raised the issue that he had some concern with the same court having some factual basis, some concern about the competency of the accused, raising that, calling for a sua sponte, and then calling for an evaluation, and then being the same court to hear the actual competency hearing if a special plea is filed. That's how it's done now. All we're doing is codifying that exact process. And this is outlined in the case of Pope v. State's 2009 case. And Ms. Travis and I took the language straight from the case and put it into this code section here. So we're tracking current case law and codifying that. So that is the practice. That's how it's done now. And that's all. Thank you.
And just to be specific about that, you are referring to the concern that was raised in lines 27 and 28. The court's order shall set forth those facts which give rise to its bona fide doubt as to the accused's mental competency to stand trial.
Yes.
That's practice currently.
That is, and that's the exact language taken from Pope v. State. Am I correct, John?
All right. I just want to make sure that was clear for everyone. What about his concern regarding either party requesting the jury trial? Did you cover that and I just missed it, or no?
If I may not have.
Okay.
And no, I did not cover it in my comments right now. The issue there is that, and I think that's a policy decision that needs to be made. But the way we've drafted this bill is so that the special plea is reserved to the defense, because that's what this is. This is a special plea. It's the defendant's right to raise his or her own question of competency. We've allowed the court, by virtue of this, we've codified the case law that allows the court to sua sponte intervene. So certainly if the prosecution wants to raise the issue, they can to the court. Court can proceed as it sees fit. But current law, obviously, both parties get a special jury trial, period. And under this amendment, it would be left to the defendant to raise that issue. And we've done that because that's the context of this particular code section 130. It's always been an issue to be raised essentially either by the court in case law or by the defendant by his or her own motion. So in tracking that special plea case law, we have left it as a demand by the defendant. Now, if the committee sees that they wish to change that policy and allow for prosecutions to raise the issue, then I defer to this committee's good judgment.
All right. Questions, Mr. Pack?
Thank you, Mr. Chairman. A question about Section 5. I think various parties have trouble with this. The question I have here is, I know you mentioned, Representative Waltz, that once they're committed, they're in the civil system, so it's not really a crime victims' rights situation. But I question whether, if you think about it, I can't imagine a situation where the Department of Behavioral Health and Development Disabilities, who has custody of the individual, would not know when that person will be released. So that argument doesn't seem to make sense to me, since your striking language of release or discharge, if you think about people who are victims of crimes, it would seem that you want to notify them that this person who's deemed to be incompetent, who was committed, is being released. I think that's the goal of the Victim Crimes Rights Act. So why strike that language, the release and discharge of, and replace any trial or hearing? It seems to me that they would know.
If I may, I think that's a very good point. And that goes to the point I'm trying to make, and I may not be making it clearly. When the department's holding someone, they're controlled. And at that point in time, current law requires them, as it is right now, whenever they're committed, current law requires them to notify of a release or discharge. What my draft of this bill has done is expanded the notification requirements to any trial or hearing. So if we eliminated Section 5, current law would stay in place, and I think that would be sufficient. This expands this to the department being responsible for keeping track of the hearings and making notification, whether it's a criminal-based hearing, a civil-based involuntary competency commitment hearing. Then it puts the burden back on the department for every hearing. So the hearings are outside of the department's control. That's set by the court. So that would be the concern with this additional language you see underlined on line 415 and 416, as well as the civilly added at line 412. So if we maintain the status quo, the way the law is, by striking this Section 5, then the current law will remain in effect, and the department will continue to have the obligation to notify the victim and the family of or just the victim, I should say, of a release or discharge from the department, as opposed to the hearings.
Mr. Setzler.
Thank you, Mr. Chairman. I know we need to make progress today. I'll try not to take too much time. I would ask that the author, as a matter of policy, do you believe that the victims ought to be given an opportunity to be aware of the hearings and or any subsequent trials, as a matter of policy?
Yes, sir, I do. I think that the question that I raise is the question of who should present them with the notification, and I think that should be the prosecuting attorney's office, as they currently do.
And I ask the question that way because there's an issue of should they have notice, and then there's the mechanics of how we go about doing that.
Yes, sir.
So I just wanted to get kind of that first, that basic, do you believe as a matter of policy, and is it your goal in this bill to make sure they find out? And I'm hearing from you that you do want to make sure that happens.
Yes, sir, that would be correct.
Okay.
I'd like them to find out, but the only concern is who's going to send the notice, and the department would like it to not be on their shoulders.
Okay. Of all the players that are in this, and this is a complex arrangement, you have civil actions coming out, arising from potentially criminal actions. What entities do you think are on the table for consideration? Obviously, the department's one, perhaps the prosecutor's another. What other entities would be available? Is there? I don't know that there's a sheriff involved in this in any consistent way that would make that relevant.
The sheriffs have been involved, but we have not really changed the current law with respect to the sheriff's obligations. So that remains essentially the same. Defense, GACTO may be concerned. They've come to subcommittee meetings and presented their concerns. I think we've addressed those concerns in the modifications that we've made through subcommittee. Of course, Superior Court judges, they've already said that they're fine with the bill. So I think at this point the changes that are at issue are left to the district attorneys and Mr. Malden's comments.
So it's your contention that it's either the prosecutor or it's the department. There's really no other entity that could track down or maintain a list of victims for certain offenses.
I'm sorry, Representative Setzer. I think you're talking about with respect to who would have the obligation of providing notice.
Yes.
I think that it would be those two entities. And certainly if someone else has a different opinion.
There's already law. It's in Crime Victims Bill of Rights. Anytime there's a trial or a hearing, whether it's a bond hearing or any in the criminal settings, it's a trial, it's a pretrial motion hearing, the obligation is on the prosecutor, and that's in 1717 in the Crime Victims Bill of Rights.
Right.
If the victim provides information allowing the prosecutor to get a hold of him, that's already clearly entitled in 1717. This Section 5 of the bill is kind of the special carve-out for DDHDD.
Now, if there's findings, as is contemplated back on page 9, that the person's found mentally incompetent and there's not substantial probability that that's going to change, then, as I understand this, they're kicked into kind of the civil world where everything else is dealing in civil context. Are the prosecutors part of the conversation at that point, or is it really just between the court and the department?
Court and department.
Okay.
Unless, as far as I know, but Mr. Malden may have some other.
I think once somebody's found not competent to stand trial, there's certain processes where they are actually, where the department does another evaluation and there's an annual review I think that Representative Welch has worked hard to make sure there was an annual review, whether it's up to 5 years or whether it's up to the maximum period of time. But the court retains jurisdiction over that. And in fact, if in fact the department suggests at this point that the person is now competent, obviously go back to trial at some point, or the person is not competent and is not likely to attain competency in the near future, would have recommendations. And in that instance, they may decide at this point, you know, we should, I don't know, release the individual. We feel the person ought to be now meets the criteria for civil commitment, or we feel the person not competent, not likely to attain competency, but we don't feel the person actually, if I state this correctly, does not meet the criteria for civil commitment anymore, and therefore he ought to be released, perhaps in some step-down unit or some community. And certainly we still are part of that process and are there at those hearings. And some of the language that I suggested, perhaps prior to any release or change from inpatient to outpatient or whatever, there'd be a hearing to ensure that the crime victim rights was impacted.
So the effect of this is when you're over in this civil realm, the prosecutor is not out of the net now, or it's just between the department and the courts. The prosecutor is throughout this process part of that conversation. Is that?
We're part of the conversation at some point throughout the process, unless and until somebody decides, all right, they are civilly committal, they ought to go through the probate process, or perhaps, you know, there's a decision saying that they're not likely to attain competency in the near future, and we don't feel they're civilly committal, but they need to be released at this point. And they have certain processes the department tries to make sure they're released. And they can explain that better than I can. But up until those points, yes, we are very much involved. You know.
Yeah, and I think that's Mr. Malden's correct. The prosecutors are still a party in sense of reviewing these evaluations, and they retain the right at any time to question the person's competency. So the bill as it is has a specific carve out in the subsection G that allows the state at any time to call for a rehearing on his competency.
Is there a problem with prosecutors? I mean, my understanding is that prosecutors have to maintain these notices if it's in a criminal context on the Crime Victims Bill of Rights. Is there a problem with prosecutors doing this for these kind of proceedings?
There's not. In fact, the language that I had basically makes sure that the Crime Victims Bill of Rights is applicable, but I'd also add some language to make sure there was a hearing. You know, there could be a process. I wanted to make sure that if, in fact, somebody's going to be released or is going to go from inpatient to outpatient to where the victim may have a chance to see them, you know, they're out and about or whatever. We ought to make sure there's a hearing before that's done so that we would know that's when we notify the victims to actually be there. See?
Do you have language to offer this committee if to bring about the public policy questions you're raising that we can entertain?
Ms. Travis, and then we're going to see if there's anybody else who needs to testify on this bill.
This code section 1717.5.1 was enacted by you all last year in House Bill 567, which was the Crime Victims Bill of Rights. So the language that's currently in the statute was the language that the prosecutors brought forward to you all last year, just so you have some historical perspective of how they wanted it to be changed. So the change now is a little bit of an issue between prosecutors and the department.
All right.
It's fresh.
Mr. Malden, thank you.
Thank you.
Is there anyone else who'd like to be heard on House Bill 421? Seeing none, what's the pleasure of the committee? Mr. Sessler.
Mr. Chairman, I'd like to perhaps consider some amendments and then move on the bill.
I need a motion first.
Move to pass.
Mr. Sessler moves due pass of House Bill 421 by substitute LC 294741 ERS, second by Ms. Abrams. Are there any amendments? I'll offer what I am perceiving to be a non-controversial amendment on line 291. The word incompetency to be struck and the word competency to be substituted in its place. So I'll repeat that, line 291. Strike the word incompetency and put in its place competency. Does the author have any objection to that amendment?
No, sir.
Is there any objection from the committee on that amendment? Seeing none, the amendment is adopted. Are there any further amendments, Mr. Ramsey? Did you have an amendment? I'm sorry. Oh, okay. Ms. Abrams.
I guess was going to defer to the author if he intended to offer AM 1021.
Well, you go ahead and offer it. He can't offer it. You go ahead and offer it.
I know he. I'd like to offer AM 291021 with one Scrivener's change on line 4. It says the court may allow the evaluation to be done, and elsewhere in the bill we've always used the word for performed. So I just changed the word done to performed.
Let me ask the author. He has no objection to the amendment. Let's just go ahead and consider that to be an amendment as opposed to an amendment Any objection on AM 291021 as amended by Ms. Abrams? Seeing none, it's adopted. Any further amendments? Seeing none, any further discussion? Mr. Coomer?
I had an additional amendment.
Okay.
In Section 5 on line 415 to put back in the language that is stricken through on lines 415 and 16 and remove the language that is underlined on lines 415 and 416.
So basically, the gentleman's amendment is to restore existing law.
That's correct.
Okay. Mr. Coomer proposes an amendment to on lines 415 and 416 to essentially restore. Well, no, it wasn't to strike the whole section. It was just to restore the.
That's correct. That's, Mr. Chairman. I was about to say, Your Honor. That's correct.
No,
Mr.
please. That's why we have Judge Boggs. Excuse me. He used to be Mike. Now he's,
Essentially, my purpose is to leave 17-17-5.1.
Just leave it alone.
Unchanged by this bill.
Okay. I'd like to go ahead and get the author's perspective on that if he has any opinion to render. I think that's relevant to the committee, not determinative, but it is relevant. Do you have any opinion on that, Mr. Welch?
I'm fine with that amendment. I think it would be helpful to be clear that we're just striking Section 5.
Oh, I see. So we're
just the entire section.
All right. You want to let's characterize it like that. I think that is better. Mr. Coomer proposes an amendment to strike Section 5. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed? The ayes have it. The amendment is adopted. Any further amendments? Mr. Setzler.
Mr. Chairman, I wanted to ask the author, I was somewhat persuaded by the prosecution's claim that perhaps the prosecution ought to be able to make a motion for a jury trial. Now, what concerns me is that might have a chaotic effect on, if the defense doesn't make the motion for a jury trial and they're assuming there's going to be a bench trial and the prosecution jumps in, I don't know how those rules play out. I don't know if there's an unintended consequence in doing that. I can understand from the perspective of victims where the prosecution senses that the conditions are such that a jury trial might facilitate more fair justice. That would seem in a certain set of facts to be the appropriate way to move forward. What are your thoughts on that?
Representative Setzler, I can certainly sympathize with the concerns of the victims. And to be just quite candid, we are talking about, I think, an internal political ping-pong ball match. And I don't intend to create that. My intention is to create a fair process under a special plea that has always been that reserved to the defendant. So,
my concern in asking the question was just that if it's not clearly specified, I don't know that you give a right for a jury trial, and then I don't know that that's workable.
I need to ask the gentleman if he's got an amendment, because that's where we're at.
No amendments, Mr. Chairman.
Okay. Mr. Atwood. All right. Ms. Abrams, did you have an additional amendment? All right. Any further discussion? Seeing none, all in favor of the gentleman's motion of due pass by substitute of House Bill 421, LC 294741 ERS, all in favor say aye. Aye. Opposed? The ayes have it. The motion is adopted. Mr. Welch, thank you for your work.
Thank you, Mr. Chairman. Thank you, members of the committee.
We're going to We're going to move to House Bill 402. Vice Chair Hatfield's House Bill 402. I know we've got a substitute of LC 294752S as in Sam. LC 294752S as in Sam.
That's correct, Mr. Chairman.
Okay.
We did have a new substitute prepared, but we've discovered some problems with that, and so we're going to work from this is the version that passed out of subcommittee, LC 294752S, and this is House Bill 402, and been commonly referred to as the expungement bill, and many of you have heard the basics of this bill in subcommittee, but I'm going to try to go through it as quickly as we can. I have two minor changes that I'm going to offer, and as I go through it, I will bring those up. Essentially, what this bill does is we do have a procedure in law now for expungement. The problem with the procedure we have now is it is fairly convoluted. It takes a tremendous amount of time because there's no there's no time limits that are really placed upon the courts in dealing with these petitions, or for that matter, prosecutors, and so it turns out to be a lengthy process. And additionally, there are instances where we seem to have pretty wide agreement that we should have the ability to provide for record restriction, or I'm using that term in lieu of expungement because the bill is not really technically an expungement bill so much as it is a bill about restricting access to records. But there are instances that I think we have some wide agreement that should be subject to allow a record to be sealed or access to be restricted that are not covered in current law. The problem that we're seeking to deal with this bill is the situation where an individual has an arrest. Sometimes it is for a fairly minor offense or offenses, and as a result of that arrest, the case may eventually be dismissed. It may be null prost, it may be dead docketed, but essentially the case is never prosecuted, or the case is prosecuted and results in an acquittal. What happens many times is that when a person who's been charged with a crime then attempts to go and secure employment, or they have a job and the employer says we're going to do a background check on our employees, they're asked to sign a form releasing GCIC, Georgia Crime Information Center records for purposes of employment. And as a result of the information then that is released by GCIC showing an arrest record, there are many employers who will either not hire a prospective employee or would discharge an employee based on the information they get. This bill is essentially aimed at the employment situation, the employment relationship, and to give individuals who have arrest records for which they were never prosecuted nor punished, the ability to have those records restricted, the access restricted, so that they would be eligible and able to secure employment rather than becoming essentially wards of the state and being on public assistance of some sort. There were some earlier discussions about extending the applicability of this provision to other areas such as housing and maybe some other things. But I think that we would be getting into some areas that we would have a hard time being able to enforce record restriction if we were to go beyond employment. And all parties seem to be in agreement that employment is really the thing we're trying to get at here. I do want to emphasize that the bill, if passed, would not in any way limit the access of law enforcement officers to arrest records of any type for any person for purposes of an investigation or prosecution. And so this is not an issue of, it's not a public safety issue from that standpoint. Prosecutors are still going to have same access, and police officers still have the same access that they have under current law to criminal history information, including arrest records. What this bill does is it will affect the information that an employer, prospective employer, is able to obtain when an individual authorizes them to obtain GCIC records. And the GCIC folks will have a code that is put in showing that it's a search for employment purposes, and the records that are ordered or would fall under a record restriction pursuant to this bill would not show up on the report. And so it will give individuals the opportunity to seek employment. This bill does not, and I want to emphasize this bill does not say anywhere that a person is authorized to lie to a prospective employer or to misrepresent his or her record. I have heard some talk about that recently, but we discussed that specifically in subcommittee, and I appreciate Chairman Ramsey's work on the bill and helping us to make it a better bill. But we specifically talked about that, and we rejected the notion that as a legislature that we should be putting a seal of approval on someone misrepresenting their record or lying about their record. So that is not in this bill. What this bill does is it gives people a fighting chance to be able to get employment and not have come in with one strike against them because they've got some arrest that was never pursued on their criminal history. And Mr. Chairman, with your permission, I'd like to just go through the sections of the bill briefly and try to answer any questions that concern those. Looking at Section 1, this will be provisions dealing with the Georgia Crime Information Center that makes clear that the records of arrest, charges, or dispositions, when access has been restricted under the new law, that those records would not be provided by the Georgia Crime Information Center. Going to Section 2, Section 2 is basically a deletion. The first few pages there, pages 2, 3, 4, and 5, are a deletion of language that is currently found in the code relating to inspection, purging, modifying, or supplementing of criminal records. And then we, beginning at line 170, are replacing that language with these new provisions of this bill. And as you see, the bill defines at lines 170 through 172 the term entity to include an arresting law enforcement agency, other law enforcement agency, including county and municipal jails and detention centers, or clerk of court's office. Lines 173 through 176 just sort of clarify existing law that says that this bill would not authorize the invasion of privacy of any person, agency, corporation, etc., other than to the extent specifically provided in the article. The lines subsection C with lines 177 through 180 provides a procedure or the general directive that the center would make an individual's criminal history record information available for review by an individual or his or her attorney upon written application to the center, and that the center would prescribe the forms and procedures for doing so. Subsection D, beginning at line 181, provides that if an individual believes his or her criminal history record information be inaccurate, incomplete, or misleading, that he or she may request a criminal history record information inspection at the center or at any entity that's in control or custody of the documentation. It also provides that there would be a fee for the inspection of the criminal history record information, which would not exceed $15, which would not include cost of fingerprinting. The fee of $15 is an amount that we came up in conjunction with the GBI, and Mr. Bankhead with the GBI is here with us, and I'm sure he'll be able to answer any questions about that. But we want to make sure that the center is able to go about their tasks in accordance with this bill and have the adequate funding to be able to do what we're asking them to do. Lines 192 through line 200 is subsection E, and it provides that if criminal history record information is believed to be inaccurate, incomplete, or misleading, then an individual can request that the entity, again, the arresting or other law enforcement agency, municipal or county jails, or clerk of court's office, to modify, correct, supplement, amend, or seal the information and notify the center of the changes within 60 days. Jails, county and municipal jails and detention centers would not be required to notify the center. And then if the entity declines to act within 60 days of the request, or if the individual is unsatisfied otherwise with the decision of the entity, then within 30 days of the end of that 60-day period, or 30 days of the issuance of the unsatisfactory decision, whichever occurs last, that the individual could then appeal to the Superior Court of the county where the entity is located. Lines 201, beginning at line 201, subsection F governs the appellate rights that are set out in subsection E. And the purpose, it says, of the appeal would be to acquire an order by the court that the subject information be modified, corrected, supplemented, amended, or sealed. The appeals will be entered in the same manner as appeals are taken from the probate court, except that the appellant will not be required to provide costs or a post bond. Notice of the appeal, the procedure for that is set out in the language there at lines 205 through 207 or 208, and then beginning at line 208, you'll see that this is going to be a de novo, or a hearing, a new hearing for the court. So the Superior Court is going to be taking it as an initial matter, and then if requested by the appellant in the notice of appeal, the court would actually hold a hearing within 90 days of the filing of appeal, provided that 90-day period can be waived by the appellant. And if the appellant requests, the appeal may be heard by the judge in chambers and also may be recorded at the request of the appellant. Beginning at line 213, subsection G, the court is required to file a decision within 60 days of the hearing. Should the court find by preponderance of the evidence that the criminal history record information is inaccurate, incomplete, or misleading, and then the court is going to enter an order consistent with its findings, essentially. The next line provides that the entity will be required to correct its records in accordance with the order of the court within 60 days, and to the extent that information has previously been disseminated to other entities or persons, that the entity would take steps to see that information, that there is a communication of the changes to that information or the modification to that information within 60 days. If the court declines to grant any relief under this provision, or if the order is just unsatisfactory to either party, whether it be the individual or the prosecuting attorney, may file an appeal, which would be a direct appeal under Code Section 5-6-34, and the applicable standard on appeal would be abuse of discretion. Subsection H is at line 230, and this is a provision that what we've been dealing with up to this point is where we're dealing with criminal history record information that is alleged to be misleading, inaccurate, or incomplete. Beginning at line 230, we are now talking about a provision where we're setting out exactly what type of criminal history record information is to be restricted. The access would be restricted to employers. And it provides that the center, GCIC, would restrict information including fingerprints or photographs of the individual taken in conjunction with the arrest for the following types of disposition. Under the cases prior to indictment or accusation, line 234, where the case was never referred for further prosecution to the prosecuting attorney by the arresting law enforcement agency either because the agency closed the case without referring it, or a period of 2 years for misdemeanor offenses or 4 years for felony offenses has elapsed from the date of arrest. And that's, of course, the general statute of limitations for misdemeanors and felonies. Or in subsection B at line 239, where the case was referred to the prosecuting attorney but was later dismissed. So those would be two instances where records would be restricted. Then after indictment or accusation, we go to line 241, subsection A, where the case was dismissed or null prossed, or the case was placed on the dead docket, and a period of 12 months has expired from the date of placing such case on the dead docket. And this is, Mr. Chairman, our first amendment I want to insert here on line 241. After the words dead docket, I want to add the words with the consent of the state. And that will make clear that if a court places, and I have said, Mr. Chairman, I have not seen, this is on line 241 at the end, after the words dead docket. I have not personally seen cases where a court has dead docketed a case over the objection of the state, but I'm told by prosecutors that in different circuits handle these things differently, and that with some dead dockets, if a person has absconded while they're on bond and unable to be located for a period of time, they move the case to the dead docket, and then if the person is eventually found, they'd bring it back, bring it off the dead docket, and go ahead and prosecute it. So we don't want those cases that fall into that sort of a category to be to have records restricted. So we're specifically providing that the state has to consent to the dead docket, and that way, if there's a case where they've got somebody who's absconded, the state will simply, would have an objection or raise an objection about that case being placed on a dead docket. Now, we'll go on to line 244. Another instance for record restriction would be where the individual went to trial but was found not guilty of the offense. And I'm not certain that our prosecutors are happy with that provision, but I would submit to the committee that if there's ever an instance where a person would be entitled to have a clean record in connection with an arrest, it's where they have actually gone through the trial process and then they have been adjudicated not guilty under the law, and as a matter of fact, they are not guilty. And so that, to me, is one of the strongest cases for granting a record restriction. At line 245, subsection C, where the individual was convicted of an offense and was sentenced to punishment other than the death penalty, but such conviction was vacated by the trial court or reversed by an appellate court, the decision of which has been made final, and the prosecuting attorney has not retried the case within 18 months of the final order of the court, unless the prosecuting attorney obtains a court order prior to the expiration of that time and gets an extension due to an ongoing investigation or other appropriate circumstances. That's left intentionally vague so that prosecutors will have the latitude to do what they need to do. And then finally at line 252, where the grand jury returned two no bills, which operates as the attachment of jeopardy as a matter of law. Beginning at line 253, we have subsection I, which deals with instances where records specifically will not be restricted. And subsection 1 at line 254, where the charges were null pros, dead docketed, or otherwise dismissed because of a plea agreement resulting in a conviction for an offense arising out of the same underlying transaction or occurrence as the conviction. So if you have a plea agreement where charges are dismissed or they're null pros or dead docketed, and it's all part of that same transaction or occurrence, then even those charges that are dismissed would still show up on the GCIC report and would be publicly available, or at least available to employers, as long as they were transactionally related. Line 257, records will also not be restricted where the charges were tried and some but not all of the charges resulted in an acquittal. So if you have a jury decision, if someone's indicted, say, for 5 offenses and the jury comes back with a conviction on 2 of those or 3 of those and an acquittal on a couple of counts, even those counts that were resulting in an acquittal would still be available to be reviewed. Line 258, subsection 3, where the conduct which resulted in the arrest of the individual was part of a pattern of criminal activity which was prosecuted in another court of this state, of the United States, another state, or a foreign nation. It makes clear that simply because there's been a dismissal in one court does not mean the case not being pursued in another court, whether state or federal or even in a foreign nation. And so those cases, again, would not be restricted. Subsection 4 at line 261, where the individual had diplomatic, consular, or similar immunity or inviolability from arrest or prosecution. I would also submit that that would be the result in a case where there's a plea bargain reached in giving an individual immunity in exchange for testimony. So those are the instances where we know that the bill would require that records not be restricted. In line 263 through 274, subsection J, we have a separate, this is really sort of a standalone paragraph here that deals with instances that are not otherwise covered by the preceding procedure, where an individual will have the ability to petition the Superior Court for the jurisdiction in which the arrest occurred, to restrict criminal history information within 4 years of the date of the arrest, and these would be situations which present extraordinary circumstances, and we have left that intentionally vague to give Superior Courts latitude in cases that would present worthy circumstances to allow record restriction, to give the courts the power to do that. If you look at line 270 where it says, provided, however, that access shall not be restricted to criminal history record information of any arrest which resulted in a felony, I'm adding the word felony, conviction of the petitioner. We'll add felony before conviction on line 271. And the thinking there is that if we have a felony case which results in a conviction for a lesser included offense that happens to be, a minor misdemeanor sort of case, then that is something that we'd want a judge to at least be able to give consideration to restricting access to records on. But we do make clear if it's a felony conviction, that's not going to apply. So any felony conviction is definitely off limits, but the judge would at least have some discretion for something that resulted in a misdemeanor conviction. It also provides at lines 271 through 274 that the court would file its order granting or denying the request within 60 days of the hearing, and then the appeal from that order would be pursuant to the direct appeal statute. Line 275, subsection K1, provides for the center to notify law enforcement, arresting and other law enforcement agencies of any record access restriction within 30 days of the date that access is restricted, and upon receipt of that notice, the agency would then have 30 days to restrict that access in their records. Then at line 283, subsection K2, provides for specific provisions for county or municipal jails or detention centers, and that they're treated a little bit differently, but what will be necessary there is not going to be an automatic process. In order to restrict those records, the individual, even under the provisions where the records are restricted in the earlier provisions of the bill relating to GCIC, the individual still has to submit a written request to the appropriate county or municipal jail or detention center, and then again within 30 days of the request, the jail or detention center is required to restrict access if in fact that is an appropriate request in that instance. Line 290, subsection 3 deals with the clerk of court's office and arrests occurring subsequent to the effective date of this code section. And the clerks have expressed some concerns about arrests that predate the effective date of the code section, and so in order to address those, we divided the clerk's provisions into arrests occurring subsequent and arrests occurring prior. The arrests that occur subsequent to the effective date of the code section will be easier for them to handle, because at the time that there is a disposition made of the case file, the clerk will simply be able to at that point in time to take whatever action is appropriate. So if there is a null pros or a dismissal at that time, then the clerk would be able, just while they've got the file in their hands, so to speak, to go ahead and take the actions to seal it or restrict access as appropriate. Then in subsection 4, line 294, as to the arrests that occur prior to the effective date of the code section, that the individual who has criminal records that are subject to be restricted by GCIC may submit a written request to the clerk and ask that the records that they maintain that are subject to be restricted be actually restricted. The clerk's office would then have 60 days. The point of that is that in order not to have a floodgate of cases that the clerk's offices are going to have to go back in and restrict access to, we're going to require some affirmative act on the part of the individual who's seeking to have the restriction put in place to go and actually make an application with the clerk's office to do that. We think that by putting that affirmative act requirement in there, that's going to probably not result in a flood of cases coming through that clerks are going to have to deal with. But it would still give any individual who is genuinely concerned about their record the opportunity to do something about it. Subsection 5 at line 300 is the provision we talked about earlier that makes clear that the information that access is restricted for would be made available only to criminal justice officials for official, judicial, law enforcement, or criminal investigative purposes. So they would have full access to the information. Line 303, subsection L, provides a procedure where under these automatic sort of restrictions that come into play with regard to GCIC, where a request is made to an entity to actually restrict the records as they're required to, and if they decline to do that in accordance with the law, then the individual can file an action in Superior Court where the entity is located under Title 50, and then the court would review that using a clear and convincing evidence standard, review the entity's decision. And as provided there, any action shall be served upon the entity, the center, that's GCIC, the prosecuting attorney having jurisdiction over the offense sought to be restricted, and the attorney general, who may become parties to the action. That is, may but are not required to. So if the attorney general's office had an interest in a case, they could become a party to it, and the same way with the local district attorney. Subsection M, line 311, says that the entity would have a duty to prevent disclosure of information to the public which would be subject to records restriction under this code section. Line 314, subsection N, is merely a restatement of provision that's in current law, and with some updating for the new terminology dealing with criminal history record information. Section 3 of the bill, beginning at line 322, makes clear that this would amend our direct appeal statute in Title 5-6-34 to add in a subsection 12, providing that the judgments or orders entered pursuant to this newly revised code section would qualify for direct appeal. Section 4 of the bill at line 328 is again existing language in the code, and we're updating the language of expunged records to criminal history record information restricted. And finally, Section 5, at line 341, provides that the act shall become effective only if one of two events occur. One, that funds are specifically appropriated for purposes of this act in an Appropriations Act making specific reference to this act, and only if funds so appropriated become available for expenditure. And I would say that GCIC has indicated to us that the computer system or the software that they need in order to be able to make this all work as is being designed to work is going to cost them essentially $60,000. And so we're making this subject to appropriation so as not to dump an unfunded mandate upon them. But then in subsection 2, at line 346, we also say that if funds are otherwise made available to the GBI for purposes of this act, provided that the director of the Bureau shall certify in writing to the Office of Legislative Counsel as staff for the Code Revision Commission that funds have been made available for such purposes and the date such funds became available. And Ms. Travis, this was she drafted that language, and I started out with some similar language, and I think she's made it better. But it basically gives the opportunity for if grant funding is made available or somehow otherwise GBI comes into the money to be able to fund the software purchase, that then the director can go ahead and certify that to Legislative Counsel and the effective date, and we can go ahead and put this thing into action. But I do make clear that under the structure of the bill at present, if that $60,000 is not there, then it doesn't move forward. So it's subject to appropriations. That's pretty much the bill, Mr. Chairman.
Thank you, Mr. Vice Chairman. Let me ask Mr. Ramsey if he wants to go and give a brief report on subcommittee action on 402.
I'll be very, very brief, Mr. Chairman. There were really kind of two issues in play here. One is the ability of first off, I think there's been a little bit of misunderstanding. This does not in any way get at records based on convictions. This is only about arrests that don't ultimately result in conviction. And the original bill kind of got at two issues. One is the ability to restrict records in the employment context, and one is the obligation of an arrestee to disclose information if asked affirmatively by the employer. I think the subcommittee, recognizing that given we're getting into employment law area, the employment law area, which certainly is not our expertise, and just as Vice Chairman Hatfield suggested, there were some constructions that were suggested that essentially would have been a sanctioning of lying by the legislature, which was really not a direction we wanted to go in. So we decided to take that out. I think it's a better bill. I think it may be something we need to study going forward in the interim, and pull some other experts in. But what we weren't comfortable with moving forward that. As it is right now, this is an issue that needs to be addressed. Vice Chairman Hatfield put a tremendous amount of work into it, and the subcommittee ultimately made a due pass recommendation to the committee.
I appreciate the subcommittee's work in general, of course, especially as it relates. Sometimes it takes a while for bills to get to a position where they can be introduced, and they end up coming in late. And this one comparatively was late, but that's not by way of criticism. That's just the process sometimes. But we work our way through as best we can. I appreciate Mr. Ramsey's work especially, and of course Mr. Setzler as well, and the work that they do. Questions for the author, Mr. Pack?
Thank you, Mr. Chairman. Mr. Vice Chair, I think I've worked with you, and during the subcommittee process, you did adopt some of the language that I suggested. A couple cleanup points on line 209.
Okay.
I think I suggested that we should have the hearing as an option, just in case. I think most of these petitions will be non-contested.
Right.
The word appellant, is it possible to say if requested by either party for a hearing? So I could foresee when the agency might have a good reason why they declined, but they don't have a statutory right for a hearing.
Well, I mean, we can certainly do that. I don't know that that is going.
Don't take it personally.
No. I don't know that there's really going to be those instances where the agency would be moving to appeal their own decision. But
with a hearing, like if they petition.
Oh, okay. As far as a hearing,
yeah. If the appellant doesn't request a hearing, there's no way to get a hearing.
Right.
That's my point.
Okay. I wouldn't have any problem with that. We just say if requested by a party, and just take out the in the notice of appeal part.
Okay. And the second thing is from line 220 on to line 225.
Okay.
I understand this provision obviously it's kind of like a clawback if you have disseminated information that's subsequently corrected by this procedure. My question is, the term previously in line 220 is not defined. So I imagine if somebody puts out a criminal history report 3 years ago and then you petition and get a court order, as it reads right now, I read it as they have to send a notice of somebody they disclosed to 3 years ago, and I don't think that was the intent. So if you're willing to limit it, maybe the date that the appeal is filed, where it stops the clock. So if they disseminate something after the petition is filed, then they have to claw back and correct that, or something like that. I don't know.
Would you be amenable to having to amending it so that it would be upon the request of the individual? So, for example, if there was a specific, party that a notice like that had been sent to, that if the individual says, well, I need this person to receive a notice, it's been corrected, then they could do it.
I think that will work.
Okay. I can do that.
Certainly. And last question is on line 244. I'm sorry. This one I have heartburn over actually. I know it's automatic that as it's drafted now, that the person who's acquitted or found not guilty, but I think there's many reasons why somebody would be found not guilty, including jury nullification, technical legal error. I would ask if you don't mind letting that fall under J, which is 263, so it wouldn't be an automatic, but something that they need to petition for, so you could fully vet that issue with the interested parties. Otherwise, other parts of the bill, I think it makes perfect sense. But I just have a little trouble with that language in 244.
I would defer to the will of the committee on it. I think that a strong argument can be made for the fact that you can't get a better disposition from a defendant standpoint than an acquittal. A dismissal or a null pros might still leave some lingering doubt out there, but from legal standpoint, an acquittal means that you're not guilty, and so I think that there are some strong policy reasons for putting that in there. However, I wouldn't also not want that to stand in the way of the bill moving forward if people do have concerns about it, which I agree. I think that there are legitimate arguments on both sides. If there are legitimate concerns about it amongst the committee, then I would certainly defer to the will of the committee. However, I think that in the event that we do that well, you're right. That would fall under subsection J. Then it basically would be an issue.
The example I have is when you have jury tampering. You get an acquittal, right, based on jury tampering, and there's double jeopardy attached. You could never get back. But you don't find that out until after the verdict. For what it's worth, I think a not guilty, if it's judgment acquittal at the close of the government's case or before the jury gets it, or even the jury comes back with the verdict before the reading of the verdict, I could completely agree with you. That's fine, because that's generally based on insufficiency of the evidence, which falls in the same category as the other categories you have listed here. But after a verdict, I have some trouble with, and so I just throw that out there for you.
I know that there have been people, including myself, that have expressed some strong feelings about that provision. But again, this is a committee process, and I respect the judgment of the committee on.
We'll let that process go forward. Mr. Setzler. Mr. Chairman, this is something I raised in subcommittee, and I know Representative Hatfield doesn't want this bill to be the Representative Hatfield tax increase of 2011.
Not at all. You know I don't.
which would read really nice on Facebook. But that having been said, in all seriousness, and I think the way he's got it structured to allow any appropriation of funds or the Bureau to find funds could invoke this, I would still offer, perhaps at an abundance of caution, that words to the effect of if adequate funds are not made available pursuant to subparagraphs 1 and 2 of the section, meaning conditions 1 and 2 are not satisfied, this act will become effective on July 1, 2013, which gives us 2.5 years for this to be in place. But at some point, we still have a date certain by which the department's got to has to, within their budget, has to allocate $60,000 to make this happen, so that this isn't something that if the General Assembly doesn't appropriate dollars and the director, out of the goodness of his heart and the moving of money, doesn't invoke this, this could linger 10 years or could go indefinitely. I think there should be some date certain that after which, and it could be, we could certainly debate the date, but I think at some point this needs to be in effect, so there is certainty when we act on this.
Again, I think Mr. Bankhead is going to say that GBI is not going to be happy with that provision because they're going to see it, and I think rightfully so, as an unfunded mandate if appropriation is not there. But I would have some reservations about that if it's going to cause the bill to stall out. But again, I defer to the committee on that decision.
And again, to the author, we're not talking $60,000 is not the realm where fiscal notes are required. Right. When you look at a departmental budget, which I've been very vocal, I believe has been squeezed. I think their investigators are underfunded. When you compare them, I'm all over that. But I think the passing of an act like this, that I think is going to get broad support from this legislature, is why budget hearings happen. And again, I think next budget cycle, potentially even in conference committee, in this legislature, we could say $60,000 needs to be put to this. And if for whatever reason it doesn't happen, you still have this date certain that through another budget cycle it's available. But I believe there needs to be some certainty here that it's not left up to an agency to potentially, again, good people all, but to just not fund this and it be indefinite, lingering out there in a way that's never invoked.
Well, I will say this, and I believe the GBI and Mr. Bankhead have been very upfront with us about the bill, and they have worked with us very well on the bill. I certainly don't think they have any intention of trying to see that the bill, not become effective just as quickly as it could. And so I feel comfortable that they're going to work diligently towards getting the bill into effect, and that I think that they see it as being, a worthwhile endeavor too. I don't want to speak for them, but in any event, I'm comfortable with it as it is. But as I said, I will defer to the committee's, thoughts on that.
Can I ask Mr. Bankhead to come forward, if you wouldn't mind? And just very briefly, Mr. Bankhead, obviously this is, you're going to want to see a separate appropriation for this. Is it the Bureau's intention to come forward with that proactive? Should this bill pass, would it be the Bureau's intention to be proactive in making that request as part of the ask for next year? Okay. I think that's a relevant question. I hope. It was just important to hear that from you, though, as opposed to me or somebody else. All right. Is there anyone in the audience who is opposed? I'm trying to be a little more respectful of the time, and I appreciate committee members' patience, but it's an important subject matter. Is anyone in the audience who is opposed to House Bill 402 who would like to be heard? Yes, sir.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee.
If you could swing the mic toward you and let us know who you are.
My name is Kermit McManus. I'm the district attorney for the Conasauga Judicial Circuit, Whitfield and Murray counties in northwest Georgia. And I've come to you to make a couple of points, if I may, very briefly. First, I think that what the Mr. Ramsey said concerning the subcommittee's belief that this needs to be addressed further in the interim is a very good idea. The prosecutors in this state have not been fully involved in this discussion of this bill. This bill was dropped in February. Prior to that time, we had not been involved in the discussions on the bill. We see very large problems with the bill as it is written. We think there are some very fertile areas within the expungement law that could be changed and should be changed, but we have not been involved in the discussions to this point. We think that there are great avenues for redress that can be made, that some of the authors' comments about why the purpose of this bill should be addressed, but we haven't had the opportunity to be involved in the discussion. We would ask that, number one, that be the will of this committee, that this bill not be passed out today, and that it be addressed over the summer and give us a chance to become more involved and have further conversations. If you would like to know specific problems we have with the bill, I'll be glad to address those as well.
I'm trying to be respectful of members' time, but I mean, I can't have you going through the entire bill. We have nothing on paper from the DAs. I assume you're speaking for the DAs Association. Is that correct?
In essence, and that's part of the problem. The DAs Association has not had a chance to look at this bill and to talk about it and to come to any conclusions because it wasn't even drafted, wasn't in writing. We had nothing to talk about at our last meeting.
When was it introduced? Yeah.
Mr. Chair.
Use that one.
Mr. Chairman, this bill was around last year, and we had extensive discussions on it. At that time, District Attorney Gary Moss was down here at the Capitol and working with us on that. And we discussed this in subcommittee the other day, that the word that we got from Gary Moss at that time, who was speaking with authority from the prosecutors as we understood it, was that the prosecutors basically did not care what was in the bill. They just wanted out of it. They just didn't want, they wanted to be taken out of it. Now they say, no, that's not what he meant by that. He said that they...
Let me make this observation. I think the prosecutors this year, for whatever reason, have been having a lot of trouble finding their voice and finding one voice and finding an organized voice. I don't know why that is, and it's not our concern. I can appreciate and frankly respect that you may, and the DA's Association may have a problem with the bill. But this issue has, but I take notice of the Vice Chair's comment. This bill has been around since last year. It was introduced a month ago or more. It was in subcommittee, and I'm sure Mr. Ramsey held an open process like we always do around here, both in sub and in full. So, and at this point we have no written materials. I've received no written materials whatsoever from the DA's Association that says to me, problem A, problem B, problem C, here's a remedy, here's a remedy. I have nothing. I have nothing. So
that's true.
Under the category of lobbying 101, it needs to be better in order to be effective. And this is sort of a help me, help you type conversation. I say that really respectfully. I really do. But there's a process here, and communication is paramount. Timely communication is even more paramount. So I'm going to defer to the subcommittee chair, who might have more perspective on that.
Well, at the risk of piling on here, your comments almost identically echoed my comments at the subcommittee hearing, where I pointed out the fact that we had not received any written comments. I would have thought, since from subcommittee to now, they would have then put some written comments together. But you said it very well. It's exactly what I said at the subcommittee hearing, and it's difficult to take seriously input on a bill when we can't point to issues that are being raised specifically.
Here's what we're going to do. We're going to entertain this bill right now. Unfortunately, our system is set up so that there are actually two bodies in this General Assembly. It is what it is. So, and I say this, I mean, I can appreciate where you're coming from, but there's plenty of time. If there are issues that the DA's Association or anyone else has, frankly, as we go along this process, I find, frankly, that it's been around for a while. I don't think maybe it's been worked as effectively as possible, but we're all guilty of that at some point with some issue around here because there's a lot going on. And so please understand that we get that and are frankly sympathetic to it. But we do have a situation where we have a bill that's ripe for a motion, ripe for amendments. We're right up on the deadline. It may go, it may not. And if it does, and Mr. Hatfield's been around here for a while, he understands the process and that we're right up on it. And, you know, it's maybe a coin toss procedurally. But if it does, and the gentleman's put in a lot of work on that, and if it does, there's a whole new opportunity over in the other body.
Yes, sir.
So I can appreciate that, but I hope you can appreciate where we're coming from as well. And we're not piling on, but we do have to treat situations the way they need to be treated.
I understand.
Thank you. I appreciate that. Let me go ahead and, in the interest of time, you confirm Ms. Abrams read my mind.
Move to pass of HB 402 LC 294752S.
Second. Ms. Abrams moves due pass of House Bill 402 by substitute LC 294752S. Second by Mr. Ramsey. Are there any amendments? Mr. Pack, did you have something, or? Yes. I'm not pushing you toward it. You had expressed earlier.
Yes.
Okay.
The first amendment I would like to offer.
Let me do this, Mr. Pack. If you wouldn't mind withdrawing for a second, I know the author had a proactive amendment, so let's go ahead and give him.
Just because he raised something that I wanted to address.
That's fine. Go ahead and use it.
I'm sorry.
Let's go ahead and have the author go ahead and
hang with us just
offer
to say
a
I want
proactive
to address
amendment.
one thing you had mentioned. I'll just go through these quickly. The first amendment that I have is with regard to, let's see, page 7, lines 241 through 243. Just in our brief conversation there, the judge indicated to me there's cases that they have that, am I right, that you put on dead docket for maybe 10 years. And so if that is a concern, here's what I was going to propose that we do is put in the amendment after dead docket on line 241, say with the consent of the state, and then on line 242 where it says and a period, we would add the language where it would say and a period prescribed by the court, comma, or a period of 12 months if no period is prescribed by the court, comma. Jill, does that make sense? So in other words, if the court lays out a time period within which the case has to stay on the dead docket, then we would respect that time period. But if the court does not specify time, then it would be 12 months. Leaves it entirely in the hands of the judge.
Yeah, come on.
I appreciate the author's willingness to address that. The concern is that the judge doesn't know when we put it on the dead docket how long it may be there. Our concern would be we use the dead docket primarily on the Superior Court level to manage our active caseload. I just took a plea on a case that had been on a dead docket for 10 years because I had issued a bench warrant, or actually I hadn't, my predecessor had, and the person was ultimately found and brought back to court, entered a plea. Technically, under this bill, unless I had known, or that judge had known at the time it was placed on the dead docket that it was going to take 10 years for the bench warrant to be executed, it could have been subjected to being dismissed. And that's really the concern. So I'm happy to work with you after it leaves this body, and we can. I've got some other suggestions too. So I'm very amenable and appreciative for your effort. But
okay. Well, that's fine. That's fine. Thank you.
Thank you very much.
So okay. Well, then I'll just amend that to the motion is to amend line 241 after dead docket and add the language with the consent of the state.
Is there any objection to the amendment? Line 241 after the word docket with the consent of the state. Is there any objection to the amendment? Hearing none, the amendment is adopted. Mr. Hatfield.
Page 8, line 271. After the words arrest which resulted in a, then add the word felony before conviction.
Say again, please.
Add the word felony before conviction.
Where are you? What?
On page 8, line 271.
Okay. Just read it once more for us, please.
Okay. Line 271, that it would read arrest which resulted in a felony conviction of the petitioner.
Is there any objection to the amendment? Seeing none, the amendment is adopted.
Okay. Mr. Chairman, do you want me to go ahead and I can address the you want me to do that one? Okay. That Mr. Pack was going to offer the amendment with regard to the not guilty finding, and just for purposes of economy on that, the motion would be to strike line 244 in its entirety, and to replace on line 245 to change the subsection C to subsection B, and then on line 252 change subsection D to subsection C.
Striking subsection B on line 244 and then read lettering accordingly.
Correct.
Is there any objection to the amendment? Seeing none, the amendment is adopted.
That's all I have.
Mr. Pack.
Thank you, Mr. Chairman. On line 209, strike the word starting the appellant in the notice of appeal and replace with words a party. Strike the words the appellant in the notice of appeal and replace with the words a party.
Is there objection to the amendment? Mr. Coomer.
I'm just reading for clarity, because the rest of the sentence requires that the notice be in, or that the request be in the notice of appeal. So if there's something requested, it would only be by the appellant in the notice of appeal. If you want something requested by the other party, then you'd make a. Am I reading that incorrectly?
I think so. I think that basically the hearing would be within 90 days of the filing of the appeal, and necessarily there'd be a notice of appeal, but either party could just file a standalone request for a hearing. So I don't see that the request itself would have any bearing on the 90-day period. Do you? So should we on 211? Should we say the parties? I guess to be consistent. You want to amend that, BJ?
Yeah. Party requesting the hearing.
Well, I think if you're going to give either party a right to ask for it, then you have to give either party a right to waive the time limits on it too. But on that you have to have both of them to agree to it to waive 90 days. So it would have to be replace the appellant with the parties. Is that right, Ms. Travis?
Either party request? Would it be a party or a party? And then there's appellant on line 212.
Right.
But the party requesting the hearing.
Mr. Chairman, I see there's a difference between the request for the hearing, which can be made by either party, but the time for holding that hearing we would presume would be not within 90 days unless both parties were agreeable that it be heard at some other time.
So it would be both parties.
That such requirement may be waived if agreed to by both parties?
Mm-hmm.
Is that, let me ask Mr. Hatfield, is that reflects your proposed amendment, the intent of your proposed amendment?
I think so, yes.
All right, then let's go ahead and summarize that then for clarity.
I guess it's actually Mr. Pack's amendment.
Oh, I'm sorry.
We sort of hijacked it.
So line 211 should read, we should strike the words the appellant at the beginning of the sentence, beginning of that line, by the appellant. So the appellant will be struck. So it should read by either party.
By both parties.
By both parties.
Mm-hmm.
By agreement of both parties. That's what it should read.
Maybe waived if agreed upon by both parties?
that's fine.
I think that's fine.
So, okay. So you should read 211, strike by the appellant, and it should read upon. No.
If agreed upon by both parties.
If agreed upon by both parties.
Okay.
Any further amendments for consistency on line 211 and 212?
I think we changed the next appellants. If the appellant requests, but afterwards.
Well, you could. I think you'd have to have both parties. So you'd say if both parties jointly request. Judge, does that sound right to you?
Put you on the spot. The hour is late. I don't think you don't want my opinion. Let's just. I remember why I got out of this place.
Well, isn't that special?
You're letting a non-appellant, the appellee, decide whether the appellant gets a bench trial or not, or gets to hear it in chambers, which I don't think is what you want to do.
Yeah.
I think appellant's fine on that portion.
Just the whole thing. Like you're right. I'm tired. Yeah.
Mr. Pack, what's your sense on the road we're going down right now? As the originator on the
except for the amendments I've offered, I think it's perfectly okay to keep if the appellant requests, because that's the person whose record you're trying to keep under seal.
Okay.
Or
Would you? I think it'd be helpful, just for clarity's sake, now for counsel, if we could, for between 207 and 212, to go ahead and get clarity on that amendment.
Okay. So starting at 208, I'll read. The court shall conduct a de novo review and shall, if requested by a party, hold a hearing within 90 days of the filing of the appeal, provided, however, that such time requirement may be waived if agreed upon by both parties. If the appellant requests, the appeal may be heard by the judge in chambers, and the proceeding shall be recorded at the request of the appellant.
Ms. Travis, do you have any reaction? That's the reaction I was hoping for. But do you have the language?
I do.
Is there any objection to the amendment? Hearing none, the amendment's adopted. Thank you.
Okay.
Any further amendments, Mr. Pack?
I do. One more. And this, I'm open to suggestions. Here's what I suggest. In line 223, after the word center and comma, put in the words, at the request of the individual whose criminal history record has been disseminated. Oh, I'm sorry. Yeah, that doesn't make any sense. Strike that, please.
When I was in 6th grade, my social studies teacher said, when in doubt, don't.
It's good advice.
It was great advice.
This,
some of the best advice of my life.
I think the intent was, and I would request the help from the other committee members, but the intent was to make sure that the individual make the request to whom the correction should be sent.
Okay.
Well, the notification of the corrections be sent.
Can I?
The author and then Ms. Abrams.
I would suggest then that we do this at lines 220 to 221, so it would read, to the extent that the entity has previously disseminated the inaccurate, incomplete, or misleading criminal history record information, comma, and upon written request by the individual whose criminal history record information is at issue, comma, notification.
Let's get that one more time.
Okay. See if I can say it the same way.
See if you
Ms.
can
Travis,
remember.
did you get it? No. Okay. I figured that. I'm going to have to learn it. Say it again. Okay. To the extent that the entity has previously disseminated the inaccurate, incomplete, or misleading criminal history record information, comma, and upon written request by the individual whose criminal history record information is at issue, comma. I think Ms. Abrams might have. You want to help? Oh, yeah. Okay.
So to the extent, the proposed amendment, and Ms. Abrams can get her chance in just a second, to the extent that the entity has previously disseminated the inaccurate, incomplete, or misleading criminal history record information, and upon written request of the individual whose criminal history information is at issue, then to read notification of each modification, etc.
Criminal history record information.
Criminal history record information. Ms. Abrams.
I have two questions of the author of the amendment and of the author of the bill. I don't understand why we would need this language. I mean, essentially what the language is requiring is if you've done it wrong, if the court decides that it has to be corrected, notification has to be sent to anyone who requested the information before. It would be the entity that the entity would know who they'd sent the wrong information to, so there's no need to further complicate how this happens. And my concern is that you may have a party that was impacted by this, but does this mean their guardian can't do it? Does this mean that someone can't request this information? I mean, you're limiting the dissemination of information that the court has adjudicated should be sent out, that information was wrong. And so I don't quite understand why we need the additional language, and I would object to it.
The reason I'm thinking about this is it says you have to send it within 60 days of the court order. Now, it doesn't limit how far you need to go back. So if you sent out something 10 years ago, as it's worded as I read it, it's requiring them to send notice out to somebody you disclosed 10 years ago.
If I can respond, Mr. Chairman.
Sure.
My concern would be that requiring that, I mean, this information can be disseminated in various ways. So the person who is, my concern is that we're limiting, number one, who can request the information be sent out. So let's say that you're guardian of someone who is impacted by this. The court makes the decision, you need the information to be sent out. This precludes anyone other than the individual sending that information out. And I don't think we want to add anything else to that clause that we've just tried to insert. But more importantly, I think that I'm less concerned about the entity having to figure out, if they know that they've sent it out to someone, I'm less concerned about their obligation to correct a mistake that they've made in the record. I think that's the obligation of the entity that sent out that information. And I'm less concerned about alleviating some administrative burden than I am making certain that the information is disseminated in a timely fashion and in accordance with the ruling of a court.
Mr. Pack, do you have a reaction?
I think it's better to limit it to who gets that information, because I think it's just overly burdensome for any agency to track down who they. We're assuming they keep that information to begin with. For example, I can imagine a law enforcement officer running criminal history on these people. It could be hundreds and hundreds of agencies that they have to notify. I'm just not quite sure. If we limit it to the specific person that the individual whose criminal history has been restricted, that person wants person A to get the notice, then I think that's a fair limitation. Because as it's worded right now, the burden's on the agency to track down everybody they sent the information to.
All right, Mr. Pack, do you want to offer the language as an amendment?
I would adopt Mr. Hatfield's language.
Okay, and Ms. Travis, I'm going to ask you to read it back for the committee. Is there objection to the amendment?
Object.
There is objection. All in favor of the amendment signify by saying aye.
Aye.
Opposed?
No.
The ayes have it. The amendment's adopted.
You ask for a recorded vote on that.
Sure. We'll all in favor of the gentleman's amendment signify by raising your right hand. Opposed? The amendment's adopted. Are there any further amendments, Mr.
Yes.
Pack?
Sorry.
I'm sorry. Did you have any more, Mr. Pack?
No.
Okay. Ms. Abrams?
And I'm not sure the posture of the committee.
We're taking amendments. We've got a motion, a second. We're doing amendments.
Well, in terms of amending an amendment or amending language that's been amended, my request would be that we include the ability of an agent or a guardian, because what we've just constrained this to is a single individual can request this information. But there may be opportunities and situations where it's not that person, it's a guardian who is seeking to assist. And I think it's important that we not constrain it to a single individual who can provide that.
That's ultimately a policy call for the committee to make. I would need the lady to present some specific language, though.
If I could remember what the line was. So upon the written request of...
And I'll go ahead and allow that for a vote, but let's get it tight.
Okay.
So that members are clear on what they're voting on. Mr.
Sessler. Because of my great affection for the author, I'm not going to offer the amendment I had drafted to provide a date certain. I would, as a clarification, however, offer, and I've got language I would propose as a friendly amendment, to simply provide certainty that on the fiscal year in which funds are available, whether it's through appropriation or through the agency, that June 30th, which is the final day of the fiscal year, would become available. I say that because if money is made available in December or appropriated through a supplemental budget, I do think there needs to be a date at the end of the year in which, if money becomes available December, it would take time for it to be implemented. If money is made available in a supplemental appropriation in March, you'd need to have some time to implement it. So it wouldn't be the date of the act. It would read, this act shall become effective on June.
Where are you exactly?
I'm sorry, I'm on line 342, Mr. Chairman.
Okay.
Apologize.
Go ahead.
It would read, this act shall, again, in the spirit of trying to perfect Representative Hatfield's concept, this act shall become effective on June 30th of the fiscal year in which funds are made available only if, and then it reads as it reads. So that whatever year funds become available, whether it's certified by the GBI director or through an Appropriations Act, the agency would have the entire year to implement the program so that on the final date it becomes effective. Because as I read this bill, these are rights to
Can we back up just a second?
Sure.
Just on the technical on that amendment. Become effective on June 30th of the year in which funds are available. Is that what you're saying?
Of the fiscal year in which funds become available.
Of the fiscal year.
So on July 1st through June 30th cycle, if the GBI director realizes in December, based on his spending glide path, we'll make these funds available, let's do this, he sends a letter to Legislative Council pursuant to paragraph 2. The date of the letter isn't the effective date, it's sort of the date. Just providing some certainty as to when this becomes effective.
No, I understand the gentleman's intent. I'm not sure that that's as easily measured as you might think, because if it's a matter of a specific line item in what I'll call the big budget, that might be able to be done. But then what that actually ends up doing is if the bureau, after going through, is able to muster the 60,000 needed in order to implement the program, I don't know that there's any readily available identifier for this is when this law will kick into effect.
That's my concern, Mr. Chairman, that if we were, for example, in the 12 budget, to get $60,000 in the budget this cycle, a fiscal year that starts in July 1st of 11 and runs through June 30th of 12, if we appropriate in the budget and go home on March 31st, what's the effective date of this by virtue of our putting this in the budget? As the language reads, I'm not sure that's clear.
Ms. Travis, have you ever seen that in terms of effective? I don't know that we can.
I mean,
that's new territory for me.
And Mr. Chairman, I've never seen
That's
this structure where there's no date.
Well, we've seen it subject to funding. We've seen that a fair amount. Mr. Travis?
I mean, the only thing that I'm thinking of is that if you wanted to say, something further about it, even though it's funded, like say it becomes next week, they say, oh, we've got the money, pretending that we're next year. Then we've got the money, and now they certify to us, and so we have a date. And you said, but you don't really want it to take effect until 6 months later. If you're trying to delay it.
I mean, if let's say we don't appropriate the dollars this year, but said the agency finds $60,000 and certifies by a letter to the legislative council that we've got we have the funds, does the director of the agency establish when this shall become effective, so that Superior Court clerks in the hinterlands have to start complying with it by a date based on the letter from the agency? I mean, it just seems.
Well, he specified the date it became available.
But if the funds become available on December 15th of 2012, this can't be effective on December 16th because you've got people all over the state that have got to comply with this.
Let me offer this. I think, and I understand where the gentleman's going because he wants to go ahead and get that finality, that closure to the issue. But I think the more expedited route on that will be for certain folks to lobby the Public Safety Subcommittee of the Appropriations Committee and get a specific line item and just get it funded. I think it's just a more predictable and more expeditious route.
So you're suggesting that in the language of the appropriations bill, they just say shall be effective X date, and is that what? But because again, this doesn't just apply to the agency turning on a database. This applies to courts all over the state when they've got to comply with these procedures, and it would just seem to me there'd need to be some certainty that when the funds become available, that at the end of the year there's. Mr. Chairman, I've given up on.
You're looking at it. You're concerned about the lag time.
Yes, sir. I've given up on my date certain idea. I mean, out of affection for the author, but the concern is that even if they put this in an Appropriations Act, when do courts and the circuits all around the state, court clerks have to comply with this? And if it's in the 2012 budget, they need to know with some certainty, is it July 1st, 2012, 2003? What is the? So if this is a rolling thing that could play out over 2 years, I'm just suggesting we say at the end of the fiscal year, or the first day of the next fiscal year after funds are appropriated, that's the effective date. So, because this is bigger than just GBI getting $60,000. Mm-hmm. That's my concern.
The author have a perspective on it?
I was just going to propose that could we add at line 344, and would this address some of your concerns if we said making specific reference to this act and only on the date funds so appropriated become available for expenditure?
No, but if they become available for expenditure, say we put this in the 2012 budget, funds are available for expenditure on July 1st of 11, but it can't become effective that date because they've not been able to implement their database. There's an implementation time involved in this. It would seem to me that when funds become available, that there's a sort of a year lag before this can be up and running, and individuals can go to their court clerk and say, I want my records to be.
I mean, I don't know. It's my perspective that, it would become effective immediately upon funding. It might take them a little while to get it actually their part up and running, but that way people could go ahead and start utilizing the procedures that are set out in the section with regard to any petitions they want to make, what have you.
And the funds would lie dormant. I mean, we have that occur plenty of times where we have an appropriation and the bureaucracy is catching up to a situation in order to take advantage of it.
If under
it's not going to go anywhere.
But Mr. Chairman, if under paragraph 2 the agency finds money and says we've got money on October 15th, is the letter of the director going to, hey, we've got funds, is that going to direct courts all over the state to begin complying with this? It just seems a little chaotic to me, and I can leave it alone, Mr. Chairman.
Mr. Bankhead.
Yeah, GCIC gets involved in these kinds of issues all the time, and issues operations bulletin, and so as does the lab, to everybody that is involved with this particular issue that goes through the Georgia Crime Information Center database. So it's fairly routine for them to implement new programs like this and to notify everybody whatever, then the operation will go into effect. So, I mean, it happens. We do it quite frequently.
Nothing further.
Okay. Mr. Coomer. No. Ms. Benfield.
Oh, I was going to ask the GBI for their opinion.
Okay.
So.
Ms. Abrams.
Going back to line 240, sorry, it's around line 221. It would be to insert after, so Representative Pack's amendment said, and upon written request by the individual. My amendment would be to insert comma by the individual, comma, or his or her designee, comma, and then continue with the remainder of his amendment.
Okay. Say that one more time so the council has got a clear.
And upon written request by the individual, comma, or his or her designee, comma.
Okay. I think it's pretty clear to the committee. Discussion. All right, we'll vote. Mr. Pack?
I defer to the senior legislator on the language.
Is there any objection to the amendment? Is there any objection? Without objection, it's adopted. Are there any further amendments? Okay. Line 346, strike the word if. Is there objection? Without objection, it's adopted. Are there any further amendments? Seeing none, on the gentleman's motion of due pass by substitute of LC 294752S, all in favor say aye. Opposed? And the motion is adopted. On House Bill 299. We'll have a notice sent out tomorrow for 10 a.m. on House Bill 299 for 10 a.m. tomorrow. I appreciate the committee's time and patience today. 10 a.m. tomorrow, notice will go out in this room. Thank you.